The October 12th, 2022 meeting of the Arlington County Board of Appeals is now in session. Good evening and welcome to this meeting of the Arlington County Board of Zoning Appeals, which is known as the BZA. I'm Lindsay Arthurs, chair of the board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Judy Freshman and board members Inta Malice, Portia Clark, and Richard Kaplan. Also present are the professional staff, including Blake Bowen, Board of Zoning Appeals Coordinator, Megan Ryan, BZA Associate Planner, Stephen Rissy, the Zoning Prim Supervisor, who's here on Teams, and Patricia Petrosini. I always worry about that. Assistant to the BZA. I think some of you guys might have reached out to her. This is our second in-person meeting in over 2 years and our second hybrid meeting in the history of the BZA. And so we still ask that you give us some considerable grace as we're trying to navigate our new technology and format. Before we call our first case, I will share with you some general information about the BZA and then some ground rules on how we conduct our meetings. The board's powers are prescribed in the Code of Virginia and set forth in detail in the county zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements of structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances for specific requirements of the zoning ordinance, and we can decide appeals of the decisions of the zoning administrator. Now, here are some specific instructions about this evening's hybrid meeting. First of all, please silence your cell phones. Applicants, if you are attending in person, when your case is called, please move to the podium in the front of the room and identify yourself. Please be sure to speak into the microphone for the benefit of those on Teams. The podium does move up and down. Speakers, please move to the podium in the front of the room when called upon. Please make sure your microphone, to speak into the microphone for the benefit of those on Teams as well. Applicants and, I said that, podium is adjustable. Tonight's meeting is also available to stream from the county website via Microsoft Teams. If board members, presenters, or speakers are attending via Teams, happen to lose internet connectivity during tonight's meeting, please reconnect with us by phone. If you're attending or viewing via Teams link, please be sure to mute your cell phones and other devices until you are called upon. Turn off the sound from any other devices to minimize interference. For those of you joining on Teams as well, please turn off your video feed until you are called upon to speak. When called upon to speak, please turn on your camera and unmute yourself by clicking the microphone icon that is located on the meeting command bar. The moderator does not have the ability to unmute you. The meeting chat is active for presenters or board members who have technical assistance only. The meeting chat should not be used for discussion, public comment, questions about agenda items, or requests for more information. All public comments must be shared verbally for the record during the assigned public testimony period. Applicants and public speakers, you will be called upon by the county staff at an assigned time. We request that all speakers pre-register for tonight. If you did not pre-register but wish to speak, speaker slips are in the box next to the clerk to the, where are they? They're in the front of the room. Thank you. Please hand them to either Blake or Meg when you have filled it out. If you are attending via Teams and wish to speak but did not pre-register, please speak to Blake Bowen. Oh, no, that doesn't work. They can't speak to you. In the chat. Yeah, if you're in Teams and wish to speak, please let us know in the chat. We'll do our best to accommodate any additional speakers if time permits. Public comment will take place only within the allotted time frames. During the public comment, the speaker timer will be displayed on the screen and on the podium. You will be muted when your time is concluded. Please be respectful of the time allotted. Lastly, this is a public forum. Today's meeting will be recorded and posted to the county website. All information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. After your case of interest is heard, you're welcome to stay for the balance of the session or to leave at your convenience. We will not hold it against you if you would like to go home. For tonight's meeting, here are the procedures. The staff reports for each case on tonight's agenda can be found on the BZA website. A link to the agenda can be found in the chat section or as well on the QR codes at the front of the room. That will take you to a link so you can view them on your device. A limited number of paper copies are available. Do we have paper copies for everybody? We do. Okay, we only have one copy, so please use the QR codes. There's a separate link in the agenda online for the supplemental material, of which there is a considerable amount for tonight's hearing. The order of our meeting is as follows. First, the cases will be called and board members will ask any questions of the county staff. Next, applicants or their representatives will be given an opportunity to make comments to support their application or appeal. Then, if there are any speakers for an item, they will be called upon at that time. After we hear from speakers for or against the proposal, the board members may permit the applicant a brief opportunity to clarify any points. The board may also ask questions of any speakers, but we do not permit and will not condone any cross-examination or direct questioning by others. You always address us. We have deemed the following time limits for applicants and speakers to be sufficient. 5 minutes for the applicants for use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for speakers for individuals. After the board has gathered all the information we need and has discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. An appeal from any decision by this board must be made to the circuit court in accordance with state law. This concludes my introductory remarks. Mr. Bowen, would you please call the first case, or Ms. Ryan? Oh, yes, we have consent agenda, correct?
Yes, I wanted to acknowledge that we also have 2 withdrawal requests. It may make sense to start with those if you're interested. I would plan to read the case language for both those cases so everyone is aware of what those cases are.
Sounds good.
And then the BZA will not need to take action on that. They were withdrawn administratively. Okay. So our 2 items that are being withdrawn are case number V-11763-22-UP-1. This is a carryover item, a use permit request by Eric Johnson on behalf of Daniel and Elise McCarthy, the owners, to permit a street setback of 21.9 feet to the wall of the addition instead of 25 feet as required from North Madison Street, and to permit a right side setback of 5 feet to the wall of the addition and the porch, 4 feet to the porch eave, and 0.2 feet to the to relocated accessory structure, a shed, instead of 10 feet to the wall of the addition, porch, and shed, 6 feet to the porch eave as required from the right side property line, and to permit an aggregate side yard width of 12.6 feet instead of 18 feet as required in the R6 zoning district regarding a new front and rear addition, front porch, relocated shed, driveway, and retaining wall on an existing one-family dwelling in the R6 zoning district on the premises known as 1918 North Madison Street in the Highland Park Overley Knolls Civic Association. The second case, which has been administratively withdrawn, is V-11776-22-VA-1. This is also a carryover item. Is a variance request by William Blackwell on behalf of Brian Vahali and William Jones, the owners, to permit a maximum lot coverage of 54.3% instead of 48% as required regarding a new in-ground pool to an existing one-family dwelling in the R6 zoning district on the premises known as 520 North Jackson Street within the Ashton Heights Civic Association. Again, both of these cases have been administratively withdrawn and do not need BZA action tonight. And I can move right into the items slated for the consent agenda if you would like.
Yes, please.
We have 2 items that are slated for an expedited approval in a group motion from the BZA. This is case number V-11785-22-UP-1, a use permit request by Caitlin and Christopher Brock, the owners, to permit a rear setback of 21.5 feet to the wall of the rear addition, 20.5 feet to the eave instead of 25 feet to the rear property line, 21 feet to the eave as requested regarding a new rear addition to an existing one-family dwelling in the R10 zoning district on the premises known as 2418 North Monroe Street in the Dover Crystal Civic Association. The second item in this group motion will be case number V-11787-22-UP-1, a use permit request by Meredith Fry and Lars Hansen, the owners, to permit a street setback of 23 feet to the wall of the second floor addition and 20 feet to the wall of the porch 18.5 feet to the porch eave instead of 25 feet to the wall of the addition, 21 feet to the porch, and 19.5 feet to the porch eave as required from the 9th road north, and to permit a rear setback of 9.3 feet to the screen porch instead of 10 feet as required from the rear property line regarding a new second-story addition, porch, and rear screen porch on an existing one-family dwelling on a corner lot in the R6 zoning district on the premises known as 948 McKinley Road within the Madison Manor Civic Association. The staff recommendation for both of the above cases is to approve the use permit request with conditions.
Madam Chair,
Yes.
I move that the Board of Zoning Appeals grant the use permits associated with the consent agenda.
I'll second it.
Wonderful. Before we take our roll call, I would like to note for the record that the reason that these cases are being considered on the consent agenda is because the applications are complete. There is no opposition to these cases. Pretty much it, right? Yeah. Just so everyone knows. All right. The motion has been made by Ms. Malice, seconded by Ms. Clark. We'll call the roll. Ms. Freshman,
Aye.
Ms. Malice,
Aye.
Ms. Clark,
Aye.
Mr. Kaplan.
Aye.
All right, the motion to grant the applications passes 4-0. That conclude 5-0. Oh, chair votes aye. That concludes this matter. Let's call the next case.
Okay, I'll acknowledge that the next case on the agenda, V-11763-22-UP-1, was one of the cases that was withdrawn at the start of the hearing. So I can move on to the following case. That is case number V-11766-22-UP-1, a carryover and revised item. This is a use permit request by Ken Reed on behalf of 3500 7th Street LLC, the owners, to permit a street setback of 11.5 feet to the porch eave instead of 19.5 feet as required, to permit a street setback of 16.1 feet to the addition over the existing non-conforming attached garage, 13.5 feet to the eave instead of 25 feet to the addition, 21 feet to the eave is required, and to permit a street setback of 13.5 feet to the upper level building eave instead of 21 feet as required, all from the easement for street purposes adjacent to 7th Street North. And then to permit a street setback of 11.6 feet to the addition over the non-existing, non-conforming attached garage, 9.9 feet to the eave, instead of 25 feet to the addition, 21 feet to the eave is required, and to permit a street setback of 20.5 feet to the new side addition, 17.9 feet to the eave instead of 25 feet to the addition, 21 feet to the eave as required, all from the easement for street purposes adjacent to North Lincoln Street, regarding a new addition over an existing non-conforming attached garage, a new left side addition, and a new porch roof to an existing one-family dwelling on a corner lot in the R6 zoning district on the premises known as 3500 7th Street North within the Ashton Heights Civic Association. The staff recommends that the board adapt the attached proposed resolution approving the use permit request with conditions. I will also acknowledge that we have several additional speakers who have signed up to speak on this case, as well as quite a bit of supplemental materials that has been submitted.
There's quite a bit of speakers. All right.
Could you describe the supplemental material?
Yes, we have an updated statement of justification from the applicants. We have an owner progress report with an arborist report and project renderings. We have neighborhood outreach report with applicants with 33 letters of support and emails from the Ashton Heights Civic Association. We also have 5 neighborhood outreach letters received from neighbors of the subject property.
I'm going to start off by saying for the record that I have absolutely not looked at the supplemental material because I did not have time today with my full-time job to read 92 pages. So I am not going to take that into account for tonight's hearing because I haven't had the time. I wish that this had been submitted before the application was prepared on Friday. I don't, it's upsetting. So board, do you guys have any questions for the staff?
Madam Chair?
Yes.
Question. According to the staff report, this current proposal has a smaller footprint and less lot coverage than the existing dwelling. Is that correct?
Yes, Ms. Malice, I believe that's true. I believe the size of the left side addition was shrunk a bit, as well as a few other modifications that probably the project architect is better equipped to describe.
But it's actually smaller than the existing structure.
I think
Oh, sorry, it's smaller than the existing structure. No, I do not believe to be that the case on account of the
I'm
left side
reading-
addition.
I'm reading the staff report.
Which page is that?
Page 2.
it was smaller than the 2 month ago proposal.
So it says the existing main building footprint is 1481 square feet.
And where exactly on page 2, Ms. Malice, are you looking?
Page 2.
Second paragraph of existing conditions.
I wish I could figure out how to make this go to my earphones. I don't think it will, though.
So it says main building footprint is 1481.
Jack, could you please mute yourself?
The existing main building footprint is indicated to be 1481 square feet. I see that line, yes.
And then on page 3, the second paragraph up, it says that the proposed main building footprint is 1426, which is, I think, smaller than the existing building.
Looking for that note now.
Second paragraph.
Second
proposed
paragraph.
Changes.
Oh.
I do see that. Let me do some
Same thing
reference.
is for coverage. It says the coverage is 1691 existing, and the new coverage is 1605.
1691 existing. I do see these numbers. They do seem to be a bit confusing. I will endeavor to do a bit of research, perhaps while the applicants are speaking.
Okay, thank you. Also, is it possible to know what the by right footprint is and what the by right coverage would be?
For a one-family dwelling on a corner lot in the R6 zoning district, I do not believe we are considering this to have a qualifying front porch. The maximum main building footprint would be 2520 square feet,
2525
or 2520.
would be the, 2525 would be the maximum main building. And the maximum coverage would be obviously, what, 40?
Without 40% without a qualifying front porch or
Okay.
detached rear garage,
All right,
correct?
so something's amiss here between the existing and the proposed.
Yes, I will look into that.
Thank you.
Anybody else have any
Can I
questions?
follow up on that?
Yes, please.
Mr. Bowen, the 2525 that you just said for the main building footprint, is the percentage lot coverage go off of the 5,000 non-conforming or the 6,000 conforming?
For a lot size that does not meet the zoning district standards, which would be 6,000 square feet, this does not. The main building footprint analysis would be calculated based on a lot size of 6,000, the minimum lot size for the district, but total lot coverage would be calculated based on the actual lot size.
Thank you.
And just for clarification, it's 2520 square feet, not 2525.
Anybody else? All right. Are the applicants here? Okay. Yeah, please.
Actually, we have 5 minutes talk, right?
Yes.
Can we set the timer for 3 minutes? Because I would like to give 2 minutes to my architect as well. So I just don't want to go over my time.
Sure. Can you raise the podium up a little bit so that we can hear you better?
There's a switch to the right
This one?
on the side. There
That's
you
the-
go. Here, he's got it.
You want to push that button again, though. There you go. You're taller. Will you push the button on the microphone again?
Good enough? Can you hear me?
Yes.
You can make it even higher so you don't have to lean.
Fancy.
Feature. Yeah, I like Arlington County. It's my first time here. Okay. First of all, I would like to introduce myself and my team. I'm Mubashir Khan, representing 3500 7th Street LLC. Owner, my partner, Mr. Wasif Faruqi, is sitting here. My other partner, Mr. Zach Abbasi, is sitting here. My attorney, Mr. Lawrence, is here as well. Since I pulled him in the case last minute, so I'll do the presentation. And then my architect, Mr. Ken Reed, is here. We have 3 neighbors who are supporting us. Ms. Loretta is sitting here. She's the resident from 1971, probably the oldest resident in the neighborhood, and she's strongly supporting our case. And then we have 2 other nice gentlemen sitting here. They're also our neighbors. They'll be supporting our case, along with 33 letters of support, which we gained this time. Last time we got 17, but of course those got canceled. So we got new round of outreach, and we get 33 letters. So, okay. What I'll try to go quickly in the next 2 minutes is we made a lot of efforts from last hearing from July. We did everything, whatever possibly we could to do this, and we went above and beyond. We did extensive outreach. We hired a lot of professionals to help us. For example, we hired arborists because there were some tree concerns from the neighbors and Ashton Heights Civic Association. So we hired an arborist. He did his initial report, tree assessment report, and it went back and forth with the AHCA organization, answered his concerns. And then our architect went multiple rounds of revisions and made a lot of changes, keeping in mind of our demands and the neighbors' concerns. And then we also hired a 3D designer on top of that, and he did a lot of changes, whatever, because we want to present the neighbors how the property will look once it's finished. So we give them soft image, and we have attached those renderings in the attachment, and I have also sent a video of that to Mr. Bowen, and he can play that, and you guys can see it's only 50 seconds of video. And then moving on, we also did, we met with our opposing neighbors from last time as well. We were advised to work with opposing neighbors. So we had 2 meetings with them on September 1st and September 29th. And we listened to their concerns, and we made first set of changes on September 1st. And then we did another set of changes on September 9th. And we made a lot of changes in the plan, which Mr. Kenreid will go over. Okay, and we reduced the square footage also. We changed a lot of design to reduce the massing, whatever their concerns were. And then moving on, as I said, we did extensive outreach. We got 33 letters of support. And then I know the staff report is also showing compatible homes on similar lots and square feet. I also added that in my honors progress report on top of what Mr. Bowen provided. We also added some more lots with less setbacks than ours. Again, our lot occupancy is only 32%, way below than 40%. Our main house footprint is only 23.8% instead of 30%. And some, okay, and that's all we have. We're not asking any height variance, no side yard, no other variances like we were last time. We're only asking street setback, and that's all I have. I missed a couple of things, but that's fine.
Thank you.
Thank you. I'm Ken Reed from RK Architects. At the last board meeting, we were requested to continue our neighborhood outreach discussions and work with the neighbors and try to resolve some of their concerns. And as a result of both the comments made at the last meeting and through our discussions with the neighbors, we did make some significant design changes. The largest of which was we changed the entire style of the house from a very modern, contemporary look to a very traditional Victorian Italianate style with the 3rd floor as a mansard roof, which is there to soften the design or the mass of the house by making the 3rd floor as a roof rather than a sheer wall. We moved the side addition back from Lincoln Avenue a bit, which allowed us to reduce the whole square footage of the project. We removed the mudroom, which is on the Lincoln Street side, as well as we are keeping a stoop, but we have it uncovered rather than as a covered stoop on the Lincoln side. We eliminated the weld exits on the west side, which were encroaching on the neighbor along 7th Street. And we were just keeping the existing small basement awning windows there. Question came up on the roof deck last time. We didn't address it because that was a bit of a surprise. The roof deck is very centered on the roof. We moved it 12 inches further away from the south neighbor, and we reduced the size of the roof deck from 172 feet to 165. On the 7th Street side, we eliminated the full front the large front porch. We're keeping the existing footprint of the front porch. But we do want to rebuild the roof to be more in keeping with the style of the house. Done.
Absolutely. Mr. Bowen, do you have an update on those numbers yet? No pressure.
Yes, to address Ms. Malice's question, admittedly, when we're putting together a staff report, we are more so focused on the proposed conditions. And so we took a look at the applicant's numbers and revised those for the proposed conditions and certified them with our zoning plan review team. We did not certify the existing numbers that were provided by the applicants for the existing conditions, since those would be changing. So my expectation, looking at the plans, is that it provided existing main building footprint is in error, and I can do some quick calculations now, hopefully to find out what I think it actually is.
It would be helpful to know the existing.
Yes, I will take a look at that now.
Do any board members have any questions for the applicants? Yeah.
Just, yeah, you need to come, one of you need to come up, because everything has to be recorded in the microphone. In one of the letters from one of the neighbors,
Right.
they say that in early September, the developer proposed to remove the roof deck and scale back the top floor. Neighbors requested to see this in writing, designs, plans, but the developers submitted their updated application to BZA staff without the changes, claiming that they had forgotten the filing deadline. Was it your intention to remove the roof deck and scale back the top floor?
Can you listen to me? Okay. No, actually, it was not my intention, but my partner, Mr. Wasif Faruqi, when we met on September 1st with the neighbors, there were a lot of things we addressed, and they keep opposing our plans. So he just said, it seems like whatever we do, you guys will never agree to that. Even if I remove this rooftop deck and if I remove this room, do you shake your hand right now? And he said, no, we cannot. But even after that, after Mr. Wasif Faruqi passed that comment, it was never agreed or it was never proposed officially. We sat back with our architect and we looked into that possibility. We could not do it. And the reason is the staircase, I think we have to remember this, what we learned at the start of the project. We are keeping existing old 1947 house, and we're keeping the basement, first floor, second floor, and there's a lot of components to that, which we have to stay. We have to design around that. Like one of that is the staircase of the house is in the middle of the house. So if we remove the room above the garage, once you go up, there's no room there. So you cannot have those bedrooms what you're trying to have. So that's the reason we are here, because it's a very, very small house. Right now, it's only 2-bedroom, 1 bath. So when we sat with our architect, he said, it's not even possible. If you remove this room, what are you going to gain with this?
Okay,
And
what about the roof deck?
Roof, okay. Yeah, the rooftop deck, no, again, that was one of the things which my partner said, but we are not removing that. And the rooftop deck is sitting where the property is as matter of right. We are not putting on that side and strategically design in the middle. And I think, as we mentioned earlier, although we bought the property on an LLC name, as soon as we bought it, Mr. Wasif Faruqi's family visited the property and they fell in love. And he said, once we develop, I want to buy that. And we have that agreement with him. So his wife and his children, because now every time we make any changes, he take it home because this is his house. So they said no, because they have sun deficiencies, and we put in the report they have some medical conditions. They want to sit in sun every day, and this is the only outdoor space. So
It's the only outdoor space?
this is the only outdoor space of the house. Because
ground level space?
No, there's as you can see, it's a small lot. There's no deck. There's no nothing out like in sun.
I think it's small because you built a big house, house on it.
No, but we are 32% lot occupancy. We are not making any bigger house. There are bigger houses than that, and as we said, like we can go up to 40% lot occupancy. We are only doing 32%.
Okay, but I think you answered my question. So you were not offering to remove the roof
No.
deck or scale back the.
Right,
Okay.
but which made some changes on the rooftop deck to concern that, as my architect said, we strategically plan the middle, we put a guardrail, nobody can walk around on the perimeter of the roof. You have only limited space there, and that's for the dining area for his family. That's.
Okay, I just wanted to know
Right.
if there was any other offers
Sure.
on the table.
Yeah, but of course, if you read my 6-page statement, I'm sorry, Miss Arthurs. I know the report was long, which we submitted, but if you can just see the 6-page honors progress report, that's a summary of everything, and you can see that how many changes, as Mr. Ken also said, we made so many changes on the plans, and this is a totally different house now. What is in July, and it's a smaller footprint, and it's a lot of changes now. So you can, as you asked for discounts, we've already made so much discounts, but I think this is the best we can come up with.
My only point is that that could have been submitted a week ago.
I'm sorry.
My only point is that that could have been submitted a week ago and we would have had time to review it.
Right, but
When we get it at 5:30 the day before the hearing, when we're all volunteers and have
course.
full-time jobs, we don't necessarily.
I understand, but the thing is, there's a lot of attachments in there, but we were diligently working towards this case so much till the last minute, till yesterday, you will not.
Then maybe we needed another month to get everything together.
No, but but I think okay, I can't comment on that. That's your
Okay.
decision, but we would like to have it today because we're already waiting from July, so.
Right.
Any other questions for me?
Madam Chair,
Yes.
I have some additional questions before he
Please.
sits down. I got a chance to review the comparables under item number 6 on your document. And so I have some questions. The first one, 2727 North George Mason Drive. Do you know where that is?
Hold on. Okay, by the way, okay, that's in Arlington.
How far is that from this house?
Probably like, I would say like 1 mile.
3.
That, okay, I don't know, because the thing is. but
1601 13th Street South. Do you know how far that is from this house?
I have no idea.
2.5.
But
729 North Barton Street. Do you know how far that is?
all I was looking is Arlington, that's all.
1.2 miles.
Arlington is a big county.
Yeah, but
1833 North Columbus. Do you know how far that one is?
no, I don't know.
That's 2.1.
But I think the main thing here is this is just a supporting document, but the staff have already recommended properties right in the neighborhood. So I think that's the main thing. That's why my first letter says, based on staff report. I'm not taking, staff report already shows the comparable houses. So the
Thank you.
staff have already done the work.
Thank
So
you.
this is just something extra which I found out, that's all.
And under number 7, just for the board's information, they're both about a mile away.
I'm sorry?
The comparable homes with less street setbacks on corner lots.
Hancock and Hartford.
Yes.
Hartford.
And then my last item at the moment, maybe more later, let me scroll up on this document. 641 North Lincoln, which is across the street that the applicant references and provides a picture of, which is Exhibit 1H for the record, is situated on a 6,250 square foot lot, which is approximately 25% bigger than the applicant's lot. And my back of the napkin calculations is that it has a main building footprint of around 1,200 square feet. Just for the record, for comparables.
Right, but
And so that, I think that covered all of the applicant's comparables in his 93-page attachment.
Got it.
right. But again, those are just addition to what staff report.
Thank you.
And the height was just to show, because the neighbors had concerns, height, we are not asking for any height variance anyway.
Thank you.
Any other questions for me?
Anyone else have any questions? I think we're good.
Not right now.
Let's move on to this very extensive list of speakers. Mr. Mayor, are you here?
Ms. Arthurs,
Yes.
before that, I would like to provide an update. I did do some calculations. I believe the existing main building footprint that we relied on from the application is a bit exaggerated or a bit larger. I calculated it to be about 1,250 in the existing main building footprint.
And can you do coverage too?
Coverage percentage, the coverage percentage or the coverage square footage?
Either.
The only other feature I believe that would count towards the total lot coverage is the driveway, which looks to be about 210 square feet. So combined with 11, or did I say 1,250?
1250.
I meant 1150.
Okay.
And then 1150 for the existing main building footprint is my calculation. And then the driveway is 210 square feet. So I believe that would bring us up to, what is that, 1350 or so?
1360.
1360. I believe the total lot coverage is 1360 square feet, and the existing main building footprint is about 1150.
Thank you.
So just the original numbers in the report were from the applicant?
Yes, they're from the submission.
All right. That's all you. Hook up one more time. There you go.
Great. Thanks
Can you move the
for the
podium?
chance to address the board again. You have my letter outlining continued opposition to this project, so I'll just
Sorry, could you
underscore.
state your name and address
Evan
again?
Marr.
An address.
Yes, 3506 7th Street, immediately adjacent to the west. Unfortunately, no serious compromise has been made on the part of the developers addressing our top concerns. The massing of this house and its roof deck. The changes you see are largely cosmetic and minor in nature. And it's essentially too big a house on too small a lot. And it's not compatible with our neighborhood as a result. It's massive by any measure. It's got twice as much above ground square footage as my house, which has an identical footprint and lot size. It would make it the largest house on our block by 750 square feet, and it's sitting on the smallest lot on our block. I'd like to draw your attention to the submission of one of my neighbors in the supplemental, pages 82 and 83, which lays out in graphic form what an outlier this house would be in Ashton Heights. It would be the single largest home in Ashton Heights among lots of 5,500 square feet or less. It would be among the top 3 largest single-family homes in Ashton Heights writ large. I'd like to also contest a couple of arguments you've heard from the developers. One, that they're keeping the existing structure. They are not. This is a tiny 1.5 story, 2-bedroom house, and they are putting a 6-bedroom, 3.5 story house in this lot. And they're doing that to maximize the size and to maximize their profit when they flip it, whenever the period that Mr. Faruqi lives in it ends. They're also cherry picking comps, as you alluded to. These are no Arlington houses with comparable square lots that require BZA relief. And the 30+ signatures that they required are not from their immediate neighbors. They've gone multiple streets over. In fact, opposition among the immediate neighbors has grown if you look at the location and the names of those who are now opposing, both in the main package and the supplemental. I ask you to deny this appeal. Thanks.
Thank you. Does anyone have any questions?
I have,
Hold on a second.
Mr. Marr,
We have questions.
one question.
Please.
You say that the structure is very different than other structure, proposed structure is very different. Now, there's a house next to it. That's your house, to the right. When I saw the video, the presentation by the applicant, it appeared to be about the same height as your home. Is
Yes.
that how you see it?
As you'll see in the letter I submitted, this 3D video that's been submitted is, I think, misleading. And it follows a pattern of misleading efforts by this group of developers to sell this house to the board and to the neighbors. You'll notice that it doesn't pan up all the way to show the roof deck. It doesn't pan side by side with my house next door. The reality is this house is massive for this lot. And we recognize that they're trying to maximize the space. They're trying to maximize whatever they can profit on this house. But I do not find that 3D model to be indicative of the size of this house compared to mine.
You believe it'll be taller than your house?
My house is 2 stories. This is 3 stories plus a roof deck. So it will tower over my house and tower even more at my neighbor on the south side, which is a 1.5 story house and sits roughly 9.5 feet from this 3-story structure that will be running the length of her property. You'll hear from her next.
So I'm just, again, a little confused which house you live in. I'm
Blue
gonna,
one.
huh?
The blue one.
The
The
blue one to
blue
the
one
west.
to the right. And so
Right.
is this Is this the blue one?
632?
No, no, I'm 3506.
Oh,
3507.
3507. Yeah, so then,
Is it just wrong on here? We have a,
We're looking at,
you're 3506, right?
I am 3506.
Okay.
you're
That makes
35.
sense because this address is 3,500, so it's got to be an even number. So I think it's just wrong on
This is
our
the,
drawing.
this has been, it should be 3506.
Yes.
Or it's a different house. Is it a different house or just different?
I don't, is there a 3507?
Let's see. Thirty-five
There is a
oh
3506.
six. 35.
assume that this is 6, it's just typical.
That's what I saw. 3507.
There's no, yeah, there's no 3507.
Oh, there's a 3507 south. There's not a 3507, so this should be 3506.
Have you seen this?
Never.
Hmm.
Yeah, no, we've ever gotten in sort of hard copy or email some of these designs. And this is showing the roof deck.
No, yeah.
Yeah, no, I mean, the roof deck is by far the most egregious element of this design. All the neighbors oppose this, and I think even one of their most ardent supporters, Miss Loretta here, has stated that she also dislikes this roof deck. It's not in keeping with the neighborhood. It's a rare feature, and it would be most unwelcome to those who are anywhere nearby. So,
Thank you.
Do you have questions?
Yeah, I had a quick question. You made a statement and I missed half of it, and then I had a follow-up. You said something about being the top 3 in Arlington. The top 3 what?
percent.
In
Top
terms of,
30% largest homes, and I'll let my colleague or my neighbor who's up here later who did the data analysis, but
that's my question is where did you get that from?
I'm going to let him answer that. It's in his submission.
And what does largest mean? But
I think by square footage likely, but I know that's not exactly the purview of the BZA, but it's a very large house, very small lot. And unfortunately, there hasn't been much in terms of compromise to address our concerns. More people are opposing it than in July, who are in the immediate vicinity, not, random neighbors 3 blocks away.
Sorry.
Go for it.
So you, in this submission that we have, there's information from you in here.
Mine is in the main package. In fact, you
Okay.
referenced.
There's nothing new from you
Nothing
in
new from me.
here.
You referenced the part about the applicants offering to
Yeah,
remove the roof deck
yes.
and scale back the 3rd floor. We wanted to see that sort of compromise throughout the process. We asked to see it in writing to see what it would look like. They sort of threw it out there and tried to get us to demand on the spot or agree on the spot. We naturally asked for time to consider it, talked to other neighbors who weren't at that particular meeting, and then they never followed through.
Okay. I just want to make sure that since there's 90 pages in here,
No,
that
there
I
are
pay attention to
Several,
anything.
I think, useful opposition letters in there, in addition to the 33 sort of stock
Okay,
letters that, they went around and collected from unsuspecting neighbors.
thank you.
Anybody else?
You have another speaker?
We have a lot of speakers. Miss Larson, are you here? Oh, Miss Larson's virtual.
I'm here. I have something to read within my 2 minutes.
Would you mind turning on your camera if you have that?
I do not have that availability. Sorry.
Okay. Can you tell us where you live?
Yes, I'm at 632 North Lincoln. I'm just south and behind of 3500.
Okay, great.
So I'll read this quickly. First of all, there's a written letter from me that's got photos in it, was submitted October 5th. I object to the revised plan, as do at least 9 truly adjacent neighbors. I've seen 10 letters totally. I don't know if the board has seen them. There is little change to the original design. It only removes 252 square feet. I could not find another Arlington property that has all of the characteristics of this particular plot of land combined with the proposed design. It would be an outlier compared to other Arlington developments. The proposed 3-story addition will tower over my house, 9.5 feet from the property line. My house, built in 1923, has as little as 20 inches between its exterior wall and that property line. The addition will be incompatible with the living conditions I've enjoyed for 33 years. It will severely block light. It will violate my privacy in 3 bedrooms and a bath and introduce noise. A rooftop deck will affect mine, my close neighbor's privacy and quiet, as well as cast nighttime illumination over all of us. My neighbors and I have communicated with the developers in good faith. On August 1, we commented that their revised design did nothing to address our concerns, but they proposed it anyway. At a meeting on September 29, we made the same comments. In closing, please do not approve the revised plan. However, Blake has advised me this is the last chance to ask for conditions, and I have several: no rooftop deck, solid privacy fence in the south, protection of my southern retaining wall. The developers offered at their cost to remove a large shared silver maple that their arborist says will not survive, and I accepted that offer. That's all I have. Thank you.
Does anyone have any questions for Ms. Larson?
Madam Chair.
Yes.
Ms. Larson, will you be standing by during this hearing so that if we get to a discussion of conditions, you can repeat the ones that you just mentioned?
Sure, I'll be happy to.
Okay. I do have, I guess, a question. This structure does not, is not asking for relief on height. So the height of this building is actually, could be built by right. Are you aware of that?
Yes, in fact, the developers told us if they're denied tonight, that's one of their options.
Okay. It's just something to think about.
I understand. Thank you.
Okay. Sure.
Anybody else? All right. Thank you, Ms. Larson. We appreciate it. All right, Mr. Teneski, I hope I'm saying that correctly. You are here virtually, I believe.
Yes, I am.
Wonderful. Can you state where you live and what you're representing the Ashton Heights Civic Association tonight?
Sure. So I am the co-chair of the Ashton Heights Civic Association's Development Committee. I live at 638 North Kenmore Street. I can see the property from my home at least in the winter. In any event, my purpose for being here is to represent the association. And the association is neutral with respect to this variance application. The association's primary development policies are maintaining lot coverage and protecting tree canopy. In this case, lot coverage is not relevant since the only proposed change to lot coverage is the expansion of an existing sunroom that would be permitted by right. And obviously, as we've already discussed, the lot coverage is below the maximum permissible. With respect to tree canopy, we've expressed concerns about protecting and replacing trees on the property with the applicant. We believe the applicant has made a good faith effort to address our concerns. At our request, the applicant engaged a certified arborist to evaluate how the development would impact trees and which ones could be protected, including one magnolia that is of particular prominence on the corner of the property. If the variance is approved, the applicant has committed in writing to engage an arborist to implement a tree preservation plan and replace removed trees with new trees that are in line with county guidelines that will be recommended by their arborist. We recognize that these commitments go above and beyond what is required of a property which will not involve the disturbance of over 2,500 square feet of land. While if it's possible, we would love for those to be added as a condition to the proposed resolution, such that they would be required to follow the tree preservation conditions that would be in place if they were disturbing over the 2,500 square foot threshold. Finally, while we understand that there are, and obviously are hearing them now, the disagreements that still exist between the applicant and surrounding neighbors, we do note that the applicant has been proactive in scheduling meetings between the applicant and the association, as well as the applicant and its neighbors. They have been responsive in the last several months to our inquiries and requests. They have kept us abreast of their changes made in response to our concerns, as well as the changes that they've made in response to neighbors' concerns. We appreciate them making a good faith effort to work with us on this project, as they have satisfactorily addressed our community-wide concerns over tree canopy, and the association does not typically take a position when there's a dispute between neighbors over such issues such as massing. We will be remaining neutral with respect to this application. Thank you very much.
Does anybody have any questions?
Well, so from the perspective of your committee, the applicant has made a concession to enact a tree preservation plan?
Correct. So the applicant, again, engaged an arborist who went through and submitted a report, maybe about a 6 or 7 page report to us, detailing the health of all of the trees on the property, as well as identifying trees that would be unlikely to survive any development, or trees that were of old age and ready for removal as it was. As Ms. Larson noted, there was a silver maple that's a jointly owned tree between their 2 properties that the arborist recommended removal for because it was 50+ years old and already starting to show poor health. As a result, they have agreed that they would again engage the arborist, if this is all approved, and replace that tree as well as any other trees with the county recommended one. So I think for that tree, it equals basically 2 trees would have to be replaced. Again, they'll engage an arborist to do that. Again, if that could be a condition, and I'm not sure it can, that's certainly something of interest to us.
So is there a tree protection plan currently, or is that to be developed?
So my understanding is that according to the county code, they don't need one or will not need one because they won't be likely to disturb over the 2,500 square feet of land. So they have not developed one, but they have committed to engaging the arborist again to basically create the tree preservation plan that would be required if they were doing a clear knockdown of the building and starting from scratch.
So
they've also expressed a desire, the future intended resident has expressed a desire to protect the trees and particularly the magnolia that's the kind of the centerpiece of that corner and hides the house from the street.
So I guess from my perspective, I think I would want to see the tree protection plan before we made it a condition. Otherwise, I'm not sure what we would be conditioning. But that's just me.
My understanding is that that's what, if this were approved, once they go to the building permit stage, that would be typically, if this were one that was a knockdown, that's what they would submit at that stage. So I think that obviously you all can figure that out, but
Yeah, I think you said that because of the land disturbance is not big enough for the county to require a tree protection plan. The only way that we would guarantee that there was one is if we conditioned it.
Correct.
Okay, great, thank you.
Anybody else have any questions? All right, thank you.
Welcome.
Valerie, I'm not going to try to, I feel like I'm going to completely butcher your last name, and I sincerely apologize. Do you want to say it?
Hello, good evening. Can you hear me?
Yes.
Thank you. Thank you for having me. My name is Valery Polkovnichenko. I'm a neighbor from the house two houses down from the property.
Can you give us your address?
3514 7th Street North. So it's 2 houses down from the property.
What time?
So
I'm sorry,
Uh,
could you say the address again?
35147th Street North.
14. Okay.
Uh, So my comment is submitted in the supplementary material, and the most important part of it is found on page 83 of the supplementary file.
All right.
So if you open to that, I can explain you what that means.
How about
So
some
the
vegetables too?
so the
Sorry. Our
someone is interrupting me. I don't know. Someone is not on mute.
Yes, please mute yourself if you're not speaking. Sorry about that.
So the applicant states in his application that the buildable area footprint would be about 1,200 square feet, even if anything is done by right, and claims that this is a restrictive condition from the current regulations. However, the existing rules allow to construct a very large home compared to other homes in Ashton Heights. So by right, they can construct about 3,600 square feet of finished above ground space. What I did, I looked at the county open portal data, which contains records of all houses, and I isolated the Ashton Heights neighborhood. So a home of that size would be in the top 6% of all single family homes in Ashton Heights by right. And if they build it at that size, it will be the second largest house, which is marked as the green circle on that picture, in among lots under 5,500 square feet. And the comparisons they're doing in the application are misleading because the improved or developed properties are on considerably larger lots. The proposal goes even further. They maximize it to 4,227 square feet. And the exhibit marks that as a red diamond. And this would be among the top 3% of all Ashton Heights single family homes. And it would be the single largest home on the lot under 5,500 square feet. So the applicant is not constrained by the zoning, but instead just seeks to maximize the size of the structure even further from this already generous possibility. And I would like to also emphasize for the board that this proposal would create unwelcome precedent for development on such small lots throughout Arlington in the future. It would create an expansive structure towering over adjacent properties, occupying almost entire rear of the lot with virtually no backyard space. And in conclusion, I urge the board to reject the proposal and developers to design a smaller structure that would fit more harmoniously in the neighborhood. Thank you for your attention.
Thank you. Does anybody have any questions? No? The very impressive graph. I think that's the first time I've seen a graph thus far. Brooke Alexander, are you here virtually? I
I
don't.
am.
Oh, fabulous.
Can you hear me?
Yes.
Okay. I'm Ashton Heights native tree and native plant and tree canopy coordinator. And I had not intended to speak tonight and just be available for questions if there were any, but there are a couple things I thought I could contribute. I was coordinating the efforts between the developers and the neighbors for a period of time. And the Alexander Juniski and Jack Spilsbury have taken over that role. But while I was doing that, we did have that meeting in early September where I just wanted to clarify, it was my understanding that the developer was offering to do, and in fact, I put it in a follow-up email to them to encourage them to actually make more concessions in terms of mass, because that seemed to be very important to the neighbors. But what I had written was that they had offered to reduce the family room by 4 feet on the west side, eliminate the exterior mudroom, eliminate the roof deck and the third floor over the garage, putting the roof deck on the third floor of the garage rather than on the roof. And so I just wanted to contribute that. The other thing that I thought I could contribute is that I did review the arborist report, and I was very appreciative that the owners did engage an arborist, because originally they felt that that 40-inch diameter maple tree could survive the construction, and they found out that it likely would not. But in the course of that, the arborist did correct his report of the size of that tree. He had made a math error. He did correct that, and I did ask him, because it's on his website as something that he does. I asked him to put down what conditions he would recommend in order if they were to do a tree preservation plan. And so I'm not sure that that is included in the report from the applicant, but I could provide it if you're interested. Thank you.
Does anyone have any questions? Okay, thank you. Jamie Moore.
Hi, thank you for having me. I am here to speak in favor of the proposed property plan.
Can you give us your address?
Oh yeah, of course. 534 North Monroe. So as Mr. Marr noted,
Sorry, can you say that again?
534 North Monroe.
Okay.
So as Mr. Marr noted, I can't claim to be truly adjacent, quote unquote, to the property, but I do walk by the street every day. And I think the house would go a long way in beautifying and modernizing the neighborhood. One that's, in comparison to other parts of Arlington, seems to be aging. Now, I read through the complaints that a lot of my neighbors, or a lot of the people in my neighborhood, brought up, and though I am sympathetic to them, I think some of them are less compelling than others. For example, they claim that the house would be sort of non-conforming and disturb the harmony of the neighborhood, as Mr. Polkovinchenko mentioned. But really, you walk down the street or any of the adjoining streets to 7th Street, and there's very little that's actually uniform about the neighborhood. There are many different houses, many different styles, some built, some quite old, some quite new. You look through the video again, or even go on Google Maps, and you'll see that there's really very little that's actually uniform about the neighborhood. So I really don't think that the proposed plan would go that far in disturbing the style or of the neighborhood all that much. And in fact, as I mentioned before, I think it would go quite a long way in sort of revamping the just the neighborhood's architecture and make it a more sort of inviting and sort of cool and modernizing place as the rest of Arlington is sort of developing to be. So I think that's why I am in support of it, and would be happy to answer any questions. Thank you.
Thank you. Does anybody have any questions? Okay, thank you. Who is next? Loretta?
Hi, I live at 701 North Lincoln Street.
I'm sorry,
701 North Lincoln Street.
Thank you.
I've been there for 51 years. And I have took care of the lady that lived in 3500 for 4 years. She was 101 when she passed away. The house that the gentlemen want to build on that, the improvements, I think will make a wonderful addition to the neighborhood. There's a house beside me at 641 that doesn't really, it doesn't fit into the neighborhood either. It's a very modern structure. So the argument that this doesn't fit in doesn't seem to be quite that relevant, because it's more, this was more of a traditional house, where the one beside me, which shades my fig tree, is very tall, because it's 3 stories tall. Now, I know it's okay on that lot because the lot's bigger. The other thing I would like to mention, that I don't agree with Mr. Evan, Mayor, saying that I didn't approve of it in my own way, of the deck on the top. But I will not object to it, because I have found that I feel that this property belongs to these people, and they should be able to build what they want and like on a piece of property that they own. I know it will shade, 641 shades my house. So, but I don't object to it and never did. So I just want to say that I am very much in favor of this house, and I would greatly appreciate it if you would approve their permit. Thank you.
Thank you. Anyone have any questions? All right. Abdul Rahman. Did I say that right? You can tell me how to say it, and I will learn.
Abdul Rahman Gabriel, 534 N Monroe Street. That's where-
534,
Yeah,
what,
N Monroe.
North Monroe?
Yeah. I'm actually, yeah, so I'm also in favor of the proposed adjustments to the property.
But you're in the same house as the previous speaker?
Yeah.
Okay.
We're roommates. Yeah, I'm new to the neighborhood. Been here about 2 months or so. And one of the first things I noticed about the neighborhood was that there was an inconsistency to the architectural structures of the households. The house behind mine and the one diagonal from the proposed property look like they belong somewhere in Hollywood. And my initial thought was, that's fine, good for them. And I'm kind of suggesting kind of the same attitude be applied here. The proposed property kind of deserves to be, as proposed, essentially. And I remain in favor of the adjustments. Yeah, that's pretty much it.
Thank you. Does anyone have any questions? Thank you. All right. Are there any other speakers? All right, board members, do you guys have any other questions? Does anyone want to make a motion? Ms. Freshman?
I'm going to move that the Board of Zoning Appeals adopt the attached proposed resolution approving use permit V-11766-22-1, subject to conditions listed in the proposed resolution. And I invite discussion.
Any seconds? All right, let's discuss.
No second?
Any seconds? No.
So motion fails.
No, motion fails. Is there another motion that anybody would like to make?
My concern is, I'm sympathetic with the neighbors about their concern, going taller and bigger. But I'm concerned about the applicant's unwillingness to make, I think, some reasonable changes to this property that could make it at least a bit more palatable. I don't know if it would make it approvable by this board, but there were changes suggested by the neighbors that were not accepted. And I guess I'm hearing that there's no interest in making those changes. So I think we have to decide this project as it stands tonight.
Go ahead.
Couple comments just for the record or for anyone, for the applicant. I think that this property has probably very little by right options that would not see the applicant back before us by looking at the plat. Right, so I see the, the discussion that we had earlier about height, that you can build this height by right. That's definitely true, but I'm not sure you could build something that would make use of that height by right. Right, so I think no matter what happens today on a deferral or a denial, this applicant is very likely to be back before us just by looking at the plat. Right, I live on a corner lot. I know corner lots are tough to build on with a 25 setback from both of the streets. That makes it very difficult to build on a corner lot. I've been before this board for similar reasons. My concern with the current proposal is essentially that the proposal is cherry picking different requirements in order to build the biggest size house on this lot that they can. And I think that staff did a fantastic job on the report, as they always do. But the staff report looks at each of the requests that the applicant is making just by that one request. So yes, we can find a house that has smaller setbacks or similar setbacks, but I don't think we can find a house of this size on this lot, or even a minimum 6,000 square foot lot that has all of the properties that we've been discussing today. And if we approve this as it is now, then this will be the new standard for every house on a small lot or undersized lot. And that's my concern. And I guess I will, whether this board moves for a lengthy deferral or a denial, like I said, I'm pretty sure this applicant will be back before us.
I believe the applicant has indicated they would like a decision.
Yeah, they were here already.
Okay. Then I guess I would be prepared to make a motion.
All right.
Bring out my notes. Scrolling through 93 pages. Madam Chair, I move that the Board of Zoning Appeals adopt,
The most important part.
I messed that one up already. I move that the Board of Zoning Appeals deny the attached proposed resolution denying the use permit V-11766-22-UP1 with the following changes. On the third whereas, strike the word not. On the fourth whereas, strike the word not. On the fifth whereas, add the word not, whereas the BZA has determined that the modification is not compatible with the development in the surrounding neighborhood, and that the structure's overall footprint, size, and placement are similar to comparable structures on other properties surrounding the lot in question, and the proposal would help preserve natural landform, historical features, and/or significant trees. On the now therefore be it resolved, strike the word approves and insert the word denies, and strike subject to the following and everything afterwards. Meaning all of the conditions.
Madam Chair, I will second the motion.
All right, the motion has been made by Mr. Kaplan, seconded by Ms. Malice. Is there any further discussion? I will call the roll. Ms. Freshman.
No.
Ms. Malice.
Aye.
Mr. Kaplan.
You missed someone.
Oh, Ms. Clark, I'm so sorry.
Aye.
Mr. Kaplan.
Aye.
I hadn't made up my mind yet. The chair votes aye. The motion to deny the application passes 4-1. That concludes this matter. All right. Mr. Bowen, will you please call the next case?
Yes, Ms. Arshers, I believe the next case will be called by Ms. Ryan.
Sorry, Ms. Ryan. Thank you.
Case number V1176822UP1 is a carryover item. A use permit request by Mary Courteous and Ori Nair, the owners, to permit left side setback of 15.3 feet to the side addition instead of 25 feet as required, a right side setback of 8.3 feet to the rear addition, 7.6 feet to the eave instead of 25 feet, 21 feet to the eave as required, and a rear setback of 21 feet, 20.5 feet to the eave to the rear addition instead of 25 feet, 21 feet to the eave as required, regarding a new side and rear addition to an existing one-family dwelling on a pipe stem lot in the R6 zoning district on the premises known as 5412 26th Street North in Yorktown. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions. And please note, we received supplemental material.
Can you please describe the supplemental material?
Yes, we have one neighborhood outreach letter.
Thank you. Board members, do we have any questions for the staff?
I'm happy with this application. I'm happy to hear from the applicant, but I do have a question for staff.
Mm-hmm.
And it was pointed out by the applicant's architect. The fact that the encroaching garage counts against the applicant does seem unfair. Do you know the policy rationale behind that?
I'm sorry, was that a question for Ms. Ryan or for myself?
It was for staff.
Either one.
Whoever wants to answer.
Yeah, Meg wrote the staff report, so I would let her take the first stab at that, but I'll be happy to jump in as needed.
Yeah, I think it's just the overall lot coverage that's on the lot itself that counts towards it.
But there's an encroaching garage that doesn't belong to the applicant, and that's counted against the applicant's coverage. And that doesn't seem fair. And I just wondered what the policy rationale was for that position.
Didn't we talk about this last
Yeah, we
time?
talked a little bit about this last week.
But I don't remember what the solution was either.
There was, right, there, I had the same question last week, and because I had sensed that the applicant would have liked to make a little bit bigger of a project, but couldn't because of that. And we, I don't remember what the answer was, but I think we moved on to a deferral.
I feel like it counts against them regardless because it's on their property line.
Correct. I would say it's very rare that this situation happens. I mean, setbacks are more or less generally met. Every once in a while, there's a non-conforming building that predates the zoning ordinance. And in this instance, it seems like it was built over the property line. And unfortunately, the way we calculate lot coverage is if a feature is on the lot within inside the parcel boundaries, it counts towards the lot coverage.
So if the applicant had come to us for a variance on lot coverage,
I'm sorry, I didn't hear the end of that from the beep on the computer.
so if the applicant had actually requested a variance for coverage to claim back that piece that was missing,
Well, they couldn't
What?
claim it back.
claim the coverage, claim the square feet,
What would staff's recommendation be?
right?
What ifs? What ifs?
Although,
I'm
we are
really
not bound
thinking-
by staff recommendation.
We're not bound, but to me, the question is, would it meet the variance standard? That this encroachment is a hardship.
Albeit temporary by some definition.
Yeah, in this instance, we did not conduct variance analysis since that was not the portion of the application. So I'm
Right.
hesitant to answer a hypothetical on an application that we don't have.
We just like putting you on the spot.
You don't want to answer hypotheticals? What's wrong?
Right, that to me is one way around. If the policy is it's on your lot, it counts regardless of whether you put it there.
Yeah.
Perhaps that's a question for the applicant, right? If the applicant would be interested in doing that, then we could discuss. If not, it's moot.
Because they're not asking for it.
Because they're not asking for it, but they probably,
Could have.
could have if they had thought about it.
Madam Chair.
Yes.
And maybe because they don't know, and if they're
Right.
not so advised, I would certainly be sympathetic to it as a hardship, but nevertheless, it would have to be a variance.
Right.
I believe I would too.
Yeah.
Yeah, we can't prejudge things, we can't
course.
prejudge hypothetical situations, but
Blake, is
it
that something
seems
you would
worth
you would
considering.
advise in the course of?
Yeah.
If there was a variance in the amount of square footage of the encroachment.
Yeah.
All right.
Is the applicant in the room?
Is the applicant in the room?
We were talking about you.
Did you want to ask me questions first? Because I had a statement, but this is kind of a curveball I didn't see coming.
We're good at that.
So you followed our conversation.
Yes.
You know, it's possible that you could have made your project bigger because, you know, by asking for a variance on coverage.
So my understanding of this, back when we first applied, and what we wanted to do originally was have a room, the room that that we now are asking for, with an attached accessible bathroom, so that they would be together. And I was advised by staff at the time that we would then have to apply for a variance, and that variances, as I understood it, are only granted if you can demonstrate that the house is not inhabitable without the variance. And clearly, since we've lived there for 20 years, the house is habitable without the variance. So it seemed to me that what staff was signaling to me was that if I didn't reduce this, it would then be a variance, not a use permit, and it would likely be rejected because we're clearly living in our house. So we didn't even pursue that. And I didn't know until I had the new plat done that there's encroachment on two sides, actually, the front, and then on one side, the neighbor's fence is 5.5 feet into my property at one point. And then when I looked into that, what I understood was that there's something called
Adverse possession.
yes.
Yeah.
And that we would have to first we would have to have a boundary plat done. The plat I had done was not a boundary plat. A boundary plat would cost between $1,000 and $1,600 to do and take several months of research at least. And then you would take the chance of going to court, and then this legal problem would arise, and there would be no certainty whatsoever that we would actually be allowed to reclaim that land in any way. I don't know if the county would require that we physically reclaimed it. And we certainly wouldn't physically reclaim the land that's being used as a carport, because the lady living there is our Greek neighbor who's 94 years old, and we would never do anything to disturb her. So it just seemed like a can of worms that I didn't even want to open. So we just went ahead and reduced it and came up with this solution of the bathroom being basically you have to walk from the addition through the kitchen to the bathroom.
If you had the opportunity to go back, would you do the plans differently? Or would you like to change the plans and go back to what you originally wanted?
If we delayed you 2 months to make what you originally wanted, would you be wanting to do that, or do you want an approval?
Well, but I'm saying first, if I had to prove all of this.
You wouldn't have to. What we were saying is that we would, because of the encroachments, that there is we think that there would be a hardship on your lot. That we would be.
Wouldn't you need for me to do the boundary research and the?
No.
No?
No.
I'm not sure about that part. I mean, clearly the garage or the carport, you know, it's easy. The boundary thing, you have a plat that shows your lot, correct?
Yes.
That's probably a question for staff.
I don't think that the fence, that encroachment doesn't factor in here, because your boundary line is still your boundary line, and the fence doesn't factor into your lot coverage in any way, shape, or form. So that's
okay.
Right. It's just the carport.
It's the carport, it's the garage.
It's not a garage, it's a carport.
Carport.
Okay, carport.
And so is that big enough to make is it just that part of it big enough to make a difference to you?
I don't think so.
Is your architect, are you looking at your architect, or you?
Right, and I believe the applicant said to make an accessible bathroom, and I believe there is a provision in a variance code for accessibility, meaning, health. I don't know.
Right. You know, if it's not necessary to go there, I wouldn't advise going there because that's more complicated. Requires a medical.
Gotcha.
All of that, maybe they have it, but it is more justification.
Well, we're looking at.
This is John Weber. He's my architect.
Okay. Did you follow our conversation?
Yes. It turns out I'm also the architect. Next people.
Oh, nice.
The amount of square footage in the encroachment was something like, I don't remember, 265, 295 square feet, which, would allow us to put the bathroom back with the wing. We wouldn't go any deeper in the lot. We'd carry the lines the same way they were. But then there could be a restroom right there for when people get a little older and want it.
A lot older.
Yeah. And that was the goal of the renovation, was to have the bathroom next to the.
Yeah, and the compromise was to shrink the wing and move it around to where the carport is so that we wouldn't encroach on any more land. And at this point, I think we were showing 65 or 90 square feet of asphalt being
90.
removed from their driveway
Yeah, we
to
have-
get our encroachment down.
Mhm.
So we might still take a little driveway up, but that would be enough room to put the bathroom back in.
So what we've done is created a decision for you.
Yeah.
Because it's, we can't grant a variance tonight. You would
Unless you
have
have a
to,
drawing in front
you'd
of you.
have to
Mhm.
have a
And it has to be
drawing,
advertised.
you'd have to make an application.
So it would be another delay.
Yeah.
But it might get you what you initially wanted. I think
Your
we're
call.
open to whatever it is that you guys want to
Totally your
do,
call.
and we can vote on this before us tonight. Or if you would like to think about it, we can also go on to the next case and you can tell us, you want to think about it for a little bit.
I think I'm ready to go with what we have tonight.
Well,
can-
and the access thing is very much central to my practice. I put the uniform federal accessibility standard was my rulemaking in '84. So I go back a long ways with access issues, having worked for the barrier board once too.
So
Okay, yeah, we'd rather take a bird in the hand than
Start,
two in the.
Yeah.
it's been delayed enough.
Madam
Well,
Chair.
and the other issue that came up last time was on the tree roots and the arborist.
Yes,
And you
That's
have
been
the memo
resolved.
from that, so.
yes,
Madam Chair.
yes.
No,
I, yeah, I would guess that at this point, if an approval for this application, which is a compromise, but nevertheless a project that could go forward, would be a wise idea as opposed to any kind of delay. And if, as upon reflection or more research, you decide you want to go for a variance, this doesn't preclude that.
That's true.
But it does allow you to go ahead with at least with your compromise.
That's true.
Okay.
If you get home tonight and you decide you don't want this anymore, then just come back and we will.
Yeah, because I'd like a chance to talk to staff and make sure I understand everything. So
Sure.
I would like to go ahead and
Okay.
go through with it tonight.
Madam Chair.
Okay.
Are there any other speakers?
No.
Great.
Madam Chair, as there are no more speakers, I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use.
Oh, hang
I
on.
didn't get to say anything.
We read the staff report.
We're ready, but we're happy to hear you as well.
I just wanted to make a very brief statement if I could.
Yes, absolutely.
Members of the Board of Zoning Appeals and Planning staff, I'm Mary Curtis, and together with my husband Ori Neer and our architect John Weber, I come before you again tonight to respectfully ask that you approve our use permit application for an addition to our home at 5412 26th Street North. I would like to again thank you for your service to our community and to thank planning staff members Blake Bowen and Megan Ryan for their work for this board and specifically for their patient willingness to answer my many questions during the application process. They serve you and our community and applicants to the BZA with integrity and dedication. We are also grateful for the support we have received from our neighbors. When we came before you last month, I explained that my husband and I are pursuing this application because we want to age in place in the home and neighborhood where we have lived for more than 20 years. Last month, one neighbor expressed concern about the impact that our addition might have on her trees and ours. We responded to those concerns by retaining a certified arborist tree risk assessment qualified with G&V Tree Service, Inc. to perform a tree risk assessment at our expense on both our property and on hers at 2527 North Jefferson Street. You have, as part of our record for this application, the detailed assessment made by that arborist, Mr. Gary Teets. He found that, quote, construction of the small addition using the pie post design for a foundation and appropriate stormwater runoff control will pose no additional threat to either our tree or our neighbor's trees. You also have a letter from the concerned neighbor, Ms. Daniel, saying that we have addressed her concerns. My architect has submitted a new plan for the foundation that meets the recommendation of the arborist. I believe that we have provided this board with ample evidence of support from all whose property could possibly be affected by our project. After a thorough analysis, staff has recommended approval. Our addition is in keeping with the character of our neighborhood. It poses no risk to the existing environment. Ori and I sincerely hope that you will approve our use permit application tonight. John, our architect, who has stuck by us over the past year through revisions and reworkings, and I are happy to answer any questions. Thank you for your consideration.
Thank you. All right.
Do you have any questions?
Thank you.
Madam Chair,
Yes.
I move that the Board of Zoning Appeals approve the attached proposed resolution in the use permit V-11768-22-UP1, subject to the conditions listed.
Second.
Motion has been made by Mr. Kaplan, seconded by Ms. Freshman. Is there any other discussion? I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to grant the application passes 5-1. You're welcome.
Ms. Curtis, we are very appreciative of your outreach to your neighbor. We thank you for that. And I hope it helps relations with your neighbors as well.
You're welcome. All right. Mr. Bowen or Mr. Ryan, will you please call the next case?
Yes, Ms. Arthurs. Just before we do that, I do want to acknowledge, I think you said the final vote in the last was 5-1. I believe it was 5-0.
It was 5-0. Thank you.
Okay.
I had
Just want
one
to
from the last
clear that
one.
up for the record.
Yeah. Thank you.
All right, our next case is case number V-11769-22-UP-1. This is also a carryover item, a use permit request by William B. Lawson Jr. on behalf of Kevin O'Brien, the owner, to permit a street setback of 17.9 feet to the existing main building, 15.9 feet to the eave, instead of 25 feet to the existing main building, 21 feet to the eave as required from the easements for public street and utility purposes for 18th Road North, regarding an existing one-family dwelling on a corner lot in the R6 zoning district on the premises known as 1808 North Randolph Street within the Cherrydale Civic Association. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions. I'd also like to acknowledge that we have additional speakers who have signed up to speak on this case, as well as some supplemental materials. I believe you will probably ask me what those supplemental materials are, so I will go ahead and volunteer that we have some correspondence from the applicant to the neighbor, and we also have a neighborhood outreach letter.
All right. Mr. Lawson.
Can I ask?
Question.
Oh, sorry. I forgot to ask my colleagues. Anyone have any questions?
Mr. Bowen,
Yes.
is all of the material in the supplemental from Mr. Kreider?
I believe we do certainly have a lot of supplemental material from Mr. Kreider. I believe we also have the one piece of supplemental material, which is correspondence provided by Mr. Lawson regarding interactions with Mr. Kreider.
So all of the historical deed is from Mr. Kreider? That's from you. Okay. I'm just trying to figure out who's submitting what.
Yes, that's correct. Thank you, Mr. Lawson.
And the Cherrydale Historic District information, that's also from the applicant. Okay. And do we know, is Chris Kreider the same as John Kreider?
Yes, he is.
Okay.
I believe we discussed it at the last hearing because we had both John and Chris on the speaker's list.
Not at all. You have a question?
I do. If Ms. Malice is done.
I'm done.
Yep. A quick question. In Mr. Kreider's comment, he made some questions, specifically 6 and 7-ish. I think there's some confusion, and so I just wanted to ask you to address that. If this board grants this boundary adjustment, then the out lot then becomes part of the neighboring lot. Is that accurate? The 6 and 7 are getting at neighbor's concern that something could, it could be sold as another lot, or something else other than an accessory structure could be built?
Any outlot that is sold in order to be deemed a buildable lot would have to meet the minimum requirements of the zoning ordinance in terms of lot area and lot width.
Which this certainly does not.
No, I do not believe it does meet those.
Right.
I can,
So
I can
there's-
pull it up, but based on my memory, that is the
Yeah,
case.
so there's not much of a concern that a house will be built on that, or going to be sold absent something that maybe the county board does.
I don't think I've ever seen an outlot be sold on its own. It's usually always in combination with another lot. And I think there's a reason that they call them outlots, because they are not buildable. So instead of
Correct.
calling it lot 2 in between the other ones, they're calling it an
I
outlet.
just wanted to address that because that seemed to be at least some, and I'm sure that Mr. Kreider can address obviously his own concerns, but at least I think that there was something that could be quickly addressed.
Good call. Yes.
Just to follow up. So this action does not, this action creates the outlot? Or it does not. It just makes the original portion, the main portion of this lot conforming. It doesn't create the outlot, and it doesn't change ownership of the outlot.
No, we can't do that.
Yeah, I mean, I'm just saying that's the only thing we're doing here is agreeing to have a non-conforming parcel. Agreeing to have a parcel that's non-conforming. Correct? That's all we're doing here.
I would characterize this as a boundary adjustment, a re-subdivision of land, adding an outlot to an existing property, transferring ownership more or
We're
less.
not subdividing.
But that's not us.
That's not us. What we're doing is allowing a lot to be.
Yes, sorry. Yeah, the overall intent of this request is to transfer ownership and go through a subdivision through the county, not strictly through the BZA. The present BZA use permit request is only to allow is only to allow the existing non-conforming dwelling to decrease in size. It still meets the minimum buildability area requirements, but generally we would not allow a property to become smaller with a non-conforming building on it unless it went through the BZA process.
So once they have this, then they can do the deed of subdivision
The first
and
step.
the plat, right?
Correct. Sorry for the
So we
confusion
don't
there.
control what happens next.
No.
We're simply.
And
How do you, but how do we say that the lot is smaller without actually having made it smaller?
If there's a follow-up question, I'll wait. That's related.
Yeah, I think my question might tie in with yours. So like what is before us today is making, let me rephrase, making this lot smaller is not necessitating the action before us, right? That the non-conforming nature exists even on the lot today. Is that a true statement?
Oh, yeah, I think it
Yeah,
did,
I'm
didn't it?
having trouble understanding
Right,
how
so-
we can create.
So right, so
Maybe
What is
Mr.
before-
Lawson will
I
explain.
feel like
this to
Mr.
us.
Lawson has the answers.
I will be happy to weigh in, but Mr. Lawson may indeed have answers.
Why don't we let him talk and see what he says?
Seems like we can't make a property smaller because it's already
but
the size it is.
I'm not sure that matters in what's before us though.
I don't think it is either.
Right, and that's what I was trying to get at.
Yeah, we're not making anything small.
Right.
No, we're not.
I mean, I kind of view what we're doing as retroactive approval to a house, that was built 70 years ago, right?
Barnes, please
96?
save us.
Sorry, it
Oh, it's not that. Oh, well, that was a while ago.
was a while ago.
All right, let's let Mr.
Okay,
Lawson
I'll
speak.
table my train of thought there.
All right, Barnes Lawson, I represent the applicant for the record. I'm going to alter my presentation a little bit. There is a provision in the zoning ordinance of Arlington, which is odd. It's not in other jurisdictions. It doesn't allow any reduction in area unless the property that is being reduced is brought into conformance with the zoning ordinance. What is not in conformance with the zoning ordinance in this instance is the front yard setback for the current house. So if you all approve that tonight, then we are free to go ahead and carve out the outlot.
Okay.
The outlot will be owned by the neighbors. They signed up to speak to explain what they want it for. And I can put a covenant in the land records that the ownership of the two must coincide and go together. That way you don't end up with an outlot that somebody owns and they're not on either side. I met with Mr. Kreider, and he and I have worked together in the past, and I'm sure that we'll be allies in the future. On this particular instance, though, obviously my clients want to go ahead and proceed. What Mr. Kreider was presenting is somewhat speculative, in my opinion. He wants to preserve the large lot for the possibility of being a duplex. That would require an amendment of the ordinance by the board. He wants to have it available for missing middle, perhaps. But I wanted to point out that even after this, the remainder lot is still going to be 8,000 square feet. And Mr. O'Brien is at the point in his life where he needs the money and he wants to use it to fix up the property. You all saw that it's overgrown and so forth. And he wants to also work on the house. The reason I submitted the historic information is this is a historic home. It was built in the 1920s, and there may be the possibility of getting some tax benefits because of the fact it's a historic home. I'm not familiar with those provisions, but he had mentioned that to me. This request is modest. It's 22 feet, 23 feet from the property line. Now, the policy back when this dedication was made, and that's why I had Mr. Caffo's memo, the policy was that you even if you grant an easement, you still measure your setback from the property line, not the rear of the easement. And that was the policy. The policy has altered, it's changed. There was an amendment to the ordinance that redefined right-of-way. So now the zoning staff is saying we measure from the back of the easement, and thus you have the exact figures that are in front of you. Some of the points that were made by Chris were, in all honesty, I think they were more applicable to a variance. And he was mentioning about a hardship and the fact that this might be self-imposed. Those are standards for the variance. We have different standards for the fact it's a use permit. This is the third case of this nature that I have had that I've brought in front of you and before you. The last one that I did, where you all approved it, it involved a use permit because the house did not comply with the side setbacks, but we also got a variance for lot width. There's no variance associated in this case. And, the staff has detailed in their report the reasons why they believe we meet the criteria for the use permit. We think this is just a very minor approval of an existing situation that's been there for many years, and we would hope that you all would see fit to grant it. Thank you very much.
Don't go away. Mr. Lawson, don't go away.
Oh, yes.
Go for it.
So the zoning ordinance says no reduction in area if a property does not conform to zoning.
Right.
And by granting this use permit, it now conforms to the
Right.
zoning. Is that
Yes,
the
ma'am.
logic? it conforms to zoning. It really doesn't
And we
conform
have to
to zoning.
conform to
But,
the
like,
zoning.
Blessing it and saying that it does.
Yeah,
But
by this approval, then we can reduce the size. It's the same thing we did, I don't know, what, 9 months ago, something like that.
The other question I had was the neighbor at 4106, which is next to 1808. Did we ever get any information from that?
No,
one?
he rejected our letter. And we also send it, where he didn't go sign for it. We also send it by regular mail, so we got it, but we haven't heard anything.
Okay.
I believe it's a landlord that's renting it.
You did your due diligence, right?
Okay, speakers.
Anyone else have any questions?
So the questions, I may want to ask you questions after we hear from Mr. Kreider.
Okay.
About some of his issues.
All right, Mr. Kreider.
Thank you. Good evening. John Christopher Kreider, 1812 North Randolph Street. Good evening. Thank you, Mr. Lawson and members of the board and also staff for your assistance in this matter. I would like to take this opportunity to outline my objections. If you haven't had a chance to see the supplemental materials, I'm just summarize the highlights. This house, as mentioned, was built in 1925 and unfortunately a potential tear down. My question is, why does it need this relief at this time if it's a pre-existing condition and there is no pending building permit? So it's a rather unusual case. The other concern I have is if it were to be torn down, but the foundation was left, then a new house could be built at this reduced setback, which potentially could be a rather large incursion. A 1925 house, 1.5 stories is fine, but something following that would partially use the foundation could in fact be a rather large structure very close to the street. And I think too that if you do favor this relief, it allows the creation of an unprotected and unbuildable outlot, and that the county then, are they reaffirming that property owners can seek release so they can sell off pieces of their property to create these unbuildable lots? I think that's a rather unusual precedent. So in the spirit of neighborliness, I do have some options that I'd like the owners to consider. One is for you to deny the use permit application so no subdivision will occur, and leave that flexibility, but give the Randalls the opportunity to work privately with Mr. O'Brien to improve the lot and have access to it. The second would be that to allow the subdivision to occur, but it creates a new conforming lot that maybe it takes in some of that easement area, but the idea is that we're creating something that's useful in the future, not just sort of an area that can't be built. And the third is to create a subdivision of the lot so that the corner, the remaining lot is at least 8,700 square feet, which does allow a duplex. The fourth is if you do allow it to go through, I'd like to perhaps for them to consider the following conditions. Provide the owners, the right, Mr. O'Brien, the right of first refusal. In other words, if the Randalls sell, could they recombine the lot, give them the first opportunity to assemble the lot. Secondly, do not allow this recombination. Maintain it as an outlot to maintain that flexibility. And finally, there are some very large trees on the property, a magnolia tree, other mature trees. If this lot were purchased, would humbly request does not be removed by the Randalls. And as Mr. Lawson mentioned, I do see greater potential for this lot, including preservation of the house. I'm very much a preservationist, but I think there are too few of these larger lots left. There are 4 adjacent apartment buildings. It's a perfectly good area to integrate multifamily. There are a lot of grad students who live nearby, not a lot of problems. So I appreciate your consideration. And just so you know, I think this is a great process. I appreciate what the Randalls are trying to do, create some backyard space for their kids. But I do think that that's short-sighted given the permanence of a decision like this. Thank you.
Does anyone have any questions?
I do.
Ms. Malice.
So you state that if we grant this use permit, a subsequent building could be built on this property at the same setback. that we've granted tonight?
If it was a partial tear down, yes, ma'am.
If it was partial tear down, right. But it could be no closer to the street than the existing house is today, correct?
Correct. Mhm.
Okay, so it could be bigger, but it's not going to be any closer to the street than the current
Yes.
house is. Okay. And also regarding the outlot, Mr. Lawson mentioned that he could create a covenant that that outlot must be owned by one or the other owners. Would that satisfy your concern regarding that outlot?
Mollifies it. I do think, though, that the Randall's lot is configured in such a way that even if they were to combine this additional outlot, that there really is no further ability to create any additional an accessory structure, anything like that. So its fate is sort of sold if it stays with the Randalls in perpetuity, because there's no opportunity. So we're reducing the density of the area if they were able to hold on to the lot.
Well, couldn't they just do a lot combination?
I'm sorry?
Couldn't they just do a lot combination and combine the lots and then build on
Perhaps,
it?
yeah, yeah. And I think those are the things that I'm interested in everyone exploring, just so we maintain that flexibility for the future. Their kids are going to grow up, maybe they move. I mean, what opportunities do they have, or Mr. O'Brien have, to sort of revisit this in the future?
With respect to, the idea that maybe a duplex or something else could be built here, I do think there'd have to be a rezoning of the entire area. It couldn't be just this lot.
To do a duplex?
To do a rezoning for a duplex, it's because right now it's zoned one
If it
family.
was 8,700 square feet,
But
it could be
a rezoning typically is not for one property. It's typically for an area.
right.
And
Yeah.
so, you would be looking at a rezoning of all of these properties nearby.
Or a very large
I
county.
think the fact that there are already 4 apartment buildings directly adjacent, there could be some justification for rezoning if that's in case the land pattern has emerged over this time.
Except that the other lots that are involved probably aren't large enough to qualify.
But they exist as multifamily today. The lots on 18th Street, 18th Road, the 4 houses to the west of 1808 are all 3, 4, and 2 unit buildings. There's 4 of them,
All in R6,
all rental.
but all in the same R6 zoning?
They couldn't be. Where are they?
On 18th Road,
He's saying all 3 to the left.
the 4 square buildings just above 1808.
So is the zoning different on those?
I can take a look at the zoning map to verify the zoning. I will say that in the R6 zoning district, any new construction, use type for duplexes, multifamily buildings would not be permitted
not be
without a
permitted,
rezoning to
right.
a higher density
So,
district.
yeah, the question is, I understand what you're saying, but I'm not sure how they came to be.
I understand.
And the right of refusal condition, I don't know if we can, that's getting into a private land deal. I don't know that we can
So are covenants.
condition that. That seems to be a covenant issue. That might be outside of our purview.
We can't. But Mr. Lawson could agree that, they could agree privately to put that in there.
Yeah, and I think just in closing, I think it just creates an awkward situation for planning for the future. I mean, when we're creating parcels of land, sub-elements of land that really there's no highest or best use that could be achieved anymore, because we've taken the value out of that land by creating it a substandard lot next to an easement that can't be built on. It really reduces the utility. And if it was a conservation easement, great, because you're taking the value out of it and keeping it and preserving it. I'd be supportive of that. But I think we're making a decision that sort of limits, valuable land that's close to transit, close to parks, very walkable, and sort of creating a situation that is less than ideal. Thank you.
Thank you. All right, Katie Randall, I think you're here virtually.
Yes, I am. Can you hear me?
Do you just you and Liam want to speak separately or together or?
We plan to speak separately.
Okay, great. Go for
I
it.
can go first and then he'll follow.
Sounds good.
Well, good evening, everyone. Thank you for taking the time. My name is Katie Randall. Yes, my husband and I, we are working with Kevin and
What
this
is your
transaction.
Address?
Oh, 4105 18th Street North. My husband and I have 3 school-age children, and we have a very simple desire to have a functional yard for our family. The kids are looking for a space to play, to watch outdoor movies, and gather with our family. I'd like to emphasize that this transaction is mutually advantageous to both us and Kevin. Kevin was not able to be here tonight, but he has made it very clear that he is aligned with this process. And as Barnes mentioned, he plans to utilize the funds to work on the landscaping and his home as well. He's into his 70s, and we've been working on this for years, and he is ready and willing to move forward. I think it's worth noting that none of our bordering neighbors have any voiced any objection. And so in conclusion, I would just like to respectfully request approval for the use permit tonight. Thank you.
Does anyone have any questions? All right, Mr. Randall.
Thank you so much for your time. Liam Randall, 4105 18th Street North. And Madam Chairman, members of the BZA, Mr. Kreider, Mr. Lawson, and those watching at home, thank you as well. We live at 4105 and have been collaborating with Kevin on purchasing the outlot to extend our backyard for play space. You know, we relocated to Arlington in 2016 after over 10 years of commuting to the DC area. And we love our neighborhood. We contribute extensively. We help to run the annual block party, host neighborhood meetups, and every December with our 3 kids playing violin, we lead, a group of neighbors door to door singing carols and seasonal greetings. We're really involved in our community. In regards to this proposed transaction, my wife and Kevin and I began engaging with Arlington County on March 3rd, 2021. A tough time for all of us. I know we were the first family in Arlington to be diagnosed with COVID. But when we reached out to Bruce Woodhams in the Development Services Bureau, we were unaware that the conversations would go on for the last 1 year, 7 months, and 1 week. Through which time we've engaged with multiple departments, people, and organizations in Arlington County. We've met with and exchanged emails with Stephen Rise, Blake Bowen, Clifton Hogan, Ben Aiken, and many others, each time following their instructions and guidance in detail at a collective, considerable expense in time and money to all of us. It's no small surprise to me that on page 5 of the staff analysis that the staff approves the use permit. As noted in the staff report, the transaction is no different than other allowed use permits in and around our neighborhood. The entire reason that Kevin even needs to seek this use permit is the construction of his house 97 years ago predated the current zoning laws. It's also one of those tricky corner lots that have been discussed multiple times this evening with the 25-foot setback. Recently, Mr. Kreider, who we have a good relationship with, has suggested multiple alternatives to the O'Brien Randall transaction. And while we engaged with the neighbor in the spring of 2022 and recently with their objections from the last meeting, Mr. Kreider is still suggesting that the BZA deny this application in favor of unsubstantiated and speculative proposals. As you have discussed in today's meeting, many of the reasons cited in today's letter and in last week's discussion are flat out wrong and factually incorrect. Some of the ones I would cite would be the ability to build a duplex or to further subdivide the lot. I don't really think there's any point in going on, although I'm happy to discuss many of our other problems with these suggestions. We've listened to both our neighbors, and both Kevin and I would love to proceed with a planned transaction. Over the last almost 2 years, your staff has become intimately familiar with our reasons for pursuing this property and the simplicity of the blocker in this transaction being completed. We beg you to please listen to the 2 owners most impacted by the property, to 90% of the neighbors that have chosen to respond today, that have chosen to respond in support of, and to your staff, and please approve our application.
Thank you. Does anyone have any questions?
Good.
Madam
Um,
Chair,
Yes.
I have a question for Mr. Lawson.
Okay.
If I could
well-
recall Mr. Lawson.
Way to go, attorney.
Lots of questions for Mr. Lawson.
Yes, sir.
Okay, I'm going to profess my ignorance here, so please,
Be kind.
pretend like I know nothing about outlots, which is probably not far from the truth. Why is this an outlot and not just an outright property transfer?
An outright property transfer, you'd have to re-subdivide both lots. And that can become very expensive and very difficult. To create an outlot is much easier and much simpler. The last case that I presented to you all, we did it the other way. This one, when you look at the plat, and I have a blow up in the staff report, if we come in with a full subdivision, I'm afraid that the Randall's lot would be required to make a dedication, and then we would be back here anyway. But if we just create the outlot on Mr. O'Brien's, we can convey it with no problem.
Thank you.
Got distracted
I-
by-
On the one question I think you all had
Oh,
is,
I have my question. I
Okay.
remember my question.
I'll be quiet.
Does the creation of the outlot limit what the Randolphs can do on that property?
I don't think so. I think all it does is benefit the Randall's property. There's an easement in the back of their property in between their house and this outlot that cannot be built upon.
Right.
So it's not they can't expand their house because of this, but they can use it for the children to play and swing sets and stuff like that.
So if there was a subsequent rezoning of this whole area to make this, let's say, R2, R2-7, could that ability just now flip over to the Randolphs? In other words, is there any reason that they could not use their complete property, both lots,
I think that private utility easement is,
except for the private
Yeah.
utility easement?
I
Would
mean, they
that,
can't expand
Well,
anything.
so,
Not, to do a duplex, right now, you have to amend the ordinance because, I don't know, 20 years ago or so, it has to be within 200 feet of a major highway
right.
or commercial.
Taking all of that aside,
Yeah.
Mr. Kreider was making an argument that 1808 could become a duplex, but I'm just wondering if
He-
105
if-
could become a duplex now that they have more
I
land
don't
area.
think so. I don't think either one could be. If you kept the 8,700 square foot minimum lot size, I don't believe either one, if this does in fact happen, I don't think either one could then apply to be a duplex based upon the area. I think he's
thought
got
you
a,
just need 7,000 square feet divided by,
sorry?
I thought it was 7,000 square feet.
I think it's 8,700.
That's what we said earlier. Is it 8,700, Blake?
No,
I will be happy to take a look. 8,700 sounds about right to me.
R2 requires 3,500 for each unit.
Well, if you rezoned it to a different category, I'm not sure what the minimum is, but if you stayed R6, R5, or whatever, it has to be 8,700 for a duplex.
I'm not following you. With a rezoning or without a rezoning?
Leaving it as zoned, which is R6. In order to do a duplex, assuming you met the other criteria,
You can do a duplex on an R6?
if it's within 200 feet of
Okay.
a major road or.
But I'm saying if there was a rezoning to R27, could 4105 qualify?
I don't know. I don't know R27
I just-
requirements.
R27 says 7,000 square feet each, a certain amount of frontage. I'm just wondering, to me, it seems like only one of the two could become a duplex. And if with the transfer of land, it's the other one could become a duplex. But
Yeah,
both
and
of
that's-
them couldn't
I mean,
be a duplex.
That's a lot of assumptions, assuming Mr. O'Brien, whoever succeeded him,
Sure.
wanted to do a duplex.
Right, I completely understand. I'm just trying to think through Mr. Kreider's argument. You mentioned a covenant, of creating a covenant.
I've done that before where you have outlots, and I'm willing to offer it if you all think it would be appropriate. Covenant that the outlot and the Randall lot would have to be conveyed together. I would be willing to do that.
And is that something, this is from Mr. Bowen, can we condition that covenant?
I believe you could, yes.
Get us some language just in case.
As someone who reads deeds for a living, I do not like that idea at all. It's fine for Mr. Lawson to do it, but I don't like us getting involved one bit. Because then I would have, from an underwriting perspective, I would have a lot of questions. Anyone else have any other questions? Anyone want to
So
make a
we also got a supplemental material handed to us from.
Would you like to read that out loud?
I, no. Did you get it, Mr. Lawson?
I'm sorry.
That we received supplemental material?
Yeah, Mr. O'Brien asked that we give that to you.
It has been so given.
Well, Mr. Randall, do we need to read this out loud?
No, you don't need to.
He requested it be read out loud?
All right, let's read it.
Who should read it on his behalf? Okay, why don't you do that? I think it's better that we're not reading it into the record.
I don't have that emotion, so maybe you should.
If you'd like to come up and read it into the record.
Do you have a copy?
I printed his request.
Thank you.
Kevin O'Brien, our neighbor, asked that this be read out loud on his behalf. No one else in the neighborhood has made me any offer for all or part of my lot. The Randall O'Brien land transaction affect no other neighbor's property rights or values. That one neighbor has a dream about what could be is useless without the means to make it happen. None of us has seen any indication that there's more than a dream in this neighbor's words. And this was what he wrote, and he put in parentheses, not spoken very tactfully. It's time for this neighbor to either put up or shut up. Assuming the neighbor admits he has nothing but a dream beyond his ability to bring to fruition, it's time for Arlington County to approve the necessary zoning variances that change nothing on the current Lot 3A and then the subsequent land transfer contract. We've been waiting far too long for this. Kevin moved into his house in 1975. He's been there for 46 years, and I think he intends to stay there for the next 46.
Thank you for reading that. I appreciate it. All right. Does anybody want to make a motion or have any more questions?
Madam Chair?
Yes.
I will make a motion.
Fabulous.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11769-22-UP-1, subject to the conditions listed.
I'll second.
A motion has been made by Ms. Malice and seconded by Ms. Clark. Is there any further discussion?
I just make a quick comment that I am just having trouble with this one in that I think what's before us is the issue of a setback. And I think that if this setback came before us, I think I would look upon it favorably with just the setback relief. And so I'm not sure how appropriate it is for me to look beyond that. But I'm struggling with that.
Okay.
For whatever that's worth. That's my kind of my thought.
Anyone have any discussion on that?
I have discussion, but I can't remember what it was, so having a little trouble with all this paper here.
Yeah, I understand. I don't like this much paper. Do you want me to go
Well, I
ahead?
know what my comment was, you know, Mr. Kreider had indicated about future plans and future ideas and how this area could grow. But the thing that governs how an area grows is the general land use plan. And the general land use plan right now doesn't signal a change for this area. And I think, you know, part of our responsibility in approving use permits is, you know, I think it probably is stated somewhere that it's in conformance with the current land use plans in our community. And right now, it is in conformance with our current land use plans. Whether someday the GLUP will change and then there'll be a subsequent rezoning, you know, that's not for us to say right now, but currently it does conform to our current land use plans.
Anyone else? Yes.
Thank you. There was some discussion of including a motion, or excuse me, including a condition requiring a recordation of a covenant, and don't think that was included in the original
It
motion.
was not included in the original motion.
Do you don't want it in there, or you do?
I am agnostic on this issue of recording a covenant.
I would not support the motion if there was a covenant in there, just for the record.
I have no
That's all.
comment
Okay.
and would address that if it were to be made.
Well, let's take a vote on what we have and see what happens. All right, the motion was made by Ms. Malice and seconded by Ms. Clark. I'm going to call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion passes 5-0. The covenant is moot. All right, that concludes this matter. Mr. Bowen or Ms. Ryan, will you please call the next case?
Yes, case V11776-22-VA-1 was a carryover item that has been withdrawn that we discussed at the beginning of the meeting and no actions to be taken. So the next case is going to be V11778-22-UP2, which is a carryover. A use permit request by Robert Muner, the owner, to permit a left side setback of 6.2 feet to the wall instead of 6.5 feet as previously approved, and to permit an aggregate side yard of 14.4 feet instead of 14.7 feet as previously approved regarding a modification to BZA use permit V-11498-19-UP-1 for a construction error of a side addition in the R6 zoning district on the premises known as 743 North Albemarle Street in Bluemont. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions.
Ms. Ryan, can you remind me why this was deferred?
This was deferred because staff needed to add in the side aggregate.
Got it. All right. Board members, do you have any questions?
For staff, are there any letters of support for this project?
So let me check on that for you.
Madam Chair,
Mm-hmm.
I viewed not having neighborhood support as not an issue, given that it's a construction error and neighborhood support would presumably have been offered at the time of the approval.
I'm sorry, can you repeat the last part? That it was a construction error and
That during the first go round, when they originally had their approval, presumably we were satisfied with the neighborhood input. I can't see that a minor construction error is any reason to resurvey the neighborhood.
I think I kind of agree with that. Yeah. Anyone have any thoughts? No? All right. Is the applicant here? All right.
How are you guys doing today?
We're here.
Um,
Ask me in 2 hours and I'll tell you a different
Yeah.
story.
so I believe your question was, why am I asking for this 0.2 inches when it was already approved during the wall check? Is that what you were asking?
No.
Oh,
I
sorry.
wasn't asking. I was simply saying that we often find there's an application, if there isn't sufficient neighborhood input, that's an issue. My comment was, this is a minor construction issue, and we would have required neighborhood input initially. But at
So-
this point, I don't see any reason to resurvey the neighborhood.
I do have the survey. I was late submitting it.
Yeah, okay.
Sorry. So I have documents here for it. No excuses. I was in the hospital.
I'm
stayed in
sorry,
the
what,
hospital.
what do you have?
Neighbor supports on, so I signed letters from all my neighbors.
Do you want us to look at that?
Sure.
Give it to Ms. Ryan.
Okay. Yeah.
So sorry about that.
Go for it.
It's pretty simple. I talked to Blake. I had a conference with him, but my contractor filed for Chapter 11, and he forged the wall check documents,
He did
which I
what?
have here to support.
He
Didn't-
forged the wall check.
The reason why, because again, so yeah. So again, I don't know any of this process. I'm just an owner. I hire somebody to do everything. He has control of all the paperwork, all the documents. When I fire him, guess what? I have to finish the project.
Yeah.
So when I finish the project, I get everything transferred to myself. I hire independent people to finish the job. Last thing, I'm getting everything done. And then they say, okay, you have to submit because you did your initial BZA. You have to do another plot. So I went and got my plot approved and I was like, well, we did a wall check, right? So I went through the permitting process. I saw what he submitted in the wall check and it said 6.5, what we initially had. So the wall check said 6.5. So I went back to the survey company to come out and they surveyed it at 6.2. I go, how did the concrete move 0.3 inches? The concrete was set, the wall check, you guys did the wall check and you said 6.5. And they said, no, we didn't. Here's the original document that we submitted to your contractor that submitted to the county. So here I am. So I talked to Blake and they said if you redo the approval process for 6.2, we'll try to get it reapproved for 6.2. So that's why I'm here.
Madam Chair,
Yes.
question. Did you have to file an application and pay for this all over again?
Did I?
You had to file an application
I did file an application, yes.
and you
Pay the fee again.
and you had to pay.
Like a
I
lot.
did, yes.
That's an expensive one.
I believe in this instance, we did not charge the building location error fee since it was not
Thank you.
anyone's particular fault.
Yes, I was
This
very,
was the lesser of the pass.
I paid the initial, whatever the standard one is, and I'm very grateful for that.
So your contractor owes you some money.
Except for he filed for
He's
chapter
Chapter
11.
11, so I can't file anything. Well, I can, but it costs me more to, yeah. So
Attorney's fees are going to be more than you'll get.
I'm
Welcome.
just trying to move on.
Yes.
And this is the last step.
Let's get you there. Does anyone want to make a motion?
I would love to make a motion.
All right, let's go.
Assuming there's no more comments.
Sounds good.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11778-22-UP2, subject to the conditions listed.
Second.
Thank you, guys. I appreciate it.
I'm sorry you're back here.
I'm very sorry you're back here.
I
All
really
right.
just hope to close these permits and never be back here again.
Don't ever
We
work
have
on
to
a
call
house
the
again.
roll.
Hold on, we're almost done.
You got to vote.
Sorry.
A motion has been made by Mr. Kaplan, seconded by Ms. Freshman. Is there any further discussion? I'm going to call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. Motion passes 5-0. I'm very sorry about this.
Thank you, guys.
Enjoy your house.
Okay, thank you. Thank you.
Madam Chair, could we take a comfort break?
Yeah, we're going to take like a 5-minute break so we can all go to the
Recharge.
recharge for just a second because we have a long night ahead of us. We will be back in just a few minutes.
We're not even halfway.
Feel free to also take a comfort break.
We're not halfway.
No, we're not halfway.
Yeah, we're about halfway.
It was easy tonight, huh? This was the other. This is such a busy week. I think I'm trying to fix myself for the rest of the week to make it through.
I know, right?
Yeah.
I was supposed to have, on Friday, I have 6 sites.
Oh, goodness.
I need them like the back of my hand right now. 'Cause I looked at it.
When you say, oh, for real estate,
Yeah.
housing close.
Yeah. I do commercial real closings. I'm an underwriter for a title company.
Okay, so it's a busy time, huh?
Fourth quarter is,
Yeah.
36 sites is probably the most I've done by myself.
If you don't know any, I need a real estate lawyer, but I need somebody probably for North Carolina.
I do. Yeah, I can definitely find somebody. South Carolina came to mind, but yeah, let me send myself an.
Okay.
North Carolina and South Carolina. States.
Yeah.
We have attorneys down there.
Okay.
As underwriters.
Well, the property's in North Carolina, but we also got one in Virginia, so.
I would go.
It's Boston.
It's pretty good.
Oh, okay.
I did a transaction with him. Quiet title action, actually. Not a subsequent sale, but.
Okay. All right.
Some caution, your mic's on, so you couldn't hear.
Okay.
All right, I think thank you all for letting us take a little break. We really appreciate it. I know you guys have been sitting here for a long time, so thank you. All right, Mr. Ryan or Miss Ryan or Mr. Bowen, would you please call the next case?
Sure. Case number V-11780-22-UP-1. Use permit request by Joseph Copeland on behalf of Munsum San and Vivian Han. The owners to permit a left side setback of 13.1 feet to the porch, 12.6 feet to the porch eave instead of 21 feet as required from both the porch and porch eave. To permit a right side setback of 22.1 feet to the bump out instead of 25 feet as required. And to permit a left side setback of 22.9 feet from the bump out instead of 25 as required regarding a front porch and rear addition to an existing one-family dwelling located on Pipestem Lot in the R6 zoning district on the premises known as 6426 22nd Street North in the Arlington East Falls Church. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions, and note there is supplemental material. The supplemental material include a new owner consent that was provided via email. And then we also have the original owner consent that was uploaded with the initial application that was missed with the staff reports.
So you had it initially, but it wasn't included?
It
Okay.
accidentally did get uploaded, yes.
Okay, so now we have 2.
Yes.
Okay. All right. Okay. Does anyone have any questions for the staff? I guess I do. Well, no, go ahead. I think one of the issues that we have right now, and maybe this is better for the applicant, but the plans were changed in March, correct? The original application is in October of 2021?
I think they're providing additional information because we are missing some of the eave setbacks, but I can check on that for you.
So I guess what I would like to know is if the plans that were sent to the neighbors were different than what is in the application.
I would suggest that we confer that detail with the applicants. I'm not sure if it's specifically what was shared with the neighbors.
That's right. You wouldn't necessarily know. That's fair. Okay, then I will come back to my question.
Mr. Bowen.
Yes.
So I was trying to figure out what actually the addition looks like. You know, there's the plat. And there's the original plat, and then there's something that happens on the back. And it refers to cantilevered bump out and a stoop.
And a new portico front of the bed.
And so when I tried to look at the drawings just sort of had in red just some lines up and down the facade. So I was actually trying to figure out what is being done.
Can I help you answer that? You guys have the plans for the initial like building plans?
Can't hear you.
Think we do?
Yes, we have floor plans and elevations included with this application packet. In terms of describing the proposal, I mean, I'm happy to take a stab at it, but if the applicant would prefer to do that, I would defer to them.
Because I'm looking at these drawings that have the red lines on it, and I'm trying to figure out what they mean.
All right, let's let the applicant answer that. Anyone have any other questions before we turn to the applicant? Go ahead.
Yeah, just a quick, come on, you can come on up. My comment's more for the applicant, but everyone can hear it. Like my concern with this application, and I think it's been alluded to, is that the feedback is a little under a year old. And that's pretty unusual in my limited experience here. And so like my concern is that feedback might be a little stale at this point. Neighbors move, opinions change, that sort of thing. So if you want to address that in your comments.
Neighbors moving, I can't address to that. It's just, we've been taking our time trying to get the building permit for this. The initial application we thought we'd get through. I'm their builder, by the way. So
okay.
I'm not really
Mr.
their
Copeland?
agent.
What's your name?
Joseph Copeland.
Okay, great.
Yeah.
Are the applicants here?
So, I mean, when we actually had a contract ready to go with this. I thought it wouldn't be any problem to get it through Arlington County. But then the pipe stem lot thing is just totally restrictive. So we discovered that and, okay, well, we should be able to get through this. And I'm quite a busy contractor. We weren't really in any big hurry to get this project underway. We were more or less taking our time. I worked with Blake and Megan, thank you, trying to figure out the setbacks, not only to the actual structure, but to the overhangs. So there was a lot of back and forth going on there, trying to figure out exactly, how that worked and what they wanted to see. And I think we got to that point of not only the setbacks to the addition, but the setbacks to the overhangs. So that's kind of where we're at now. I think we got everything clear. And that's why we're here tonight.
So,
but if you're concerned about what we're doing, the back of the house, the second floor cantilevers out 2 feet, not across the entire back.
so that's a cantilever that we see on the.
Right. So there's no foundation for this addition, simply cantilevering the joists out on the second floor only, 2 feet to expand 1 bedroom and the master bathroom.
Okay.
So yeah, there's no foundation or columns or anything like that. And then the front porch, I think, kind of speaks for itself. Do you have a set of the building plans there?
So we do, we have floor plans, And then we
Right.
have some elevations.
Oh, you don't have elevations?
No, we do have
Oh, you do?
elevations, but the elevations are marked up with these red lines, 6 inches, 0 inches.
Right, that was probably me attempting to clarify the setbacks.
And then
Yeah.
so I was trying to figure out what we were trying to portray there.
The setbacks,
This-
very poorly.
So I see there's the cantilever there. Okay, I see that. And then I see the front of the porch. And it says 6 inches, and those are the eaves? Is that what the 6
Correct.
inches refer to? Okay, so the project is basically you're cantilevering the second story and you're
That
building,
portion of the second floor, I think it's 20 feet roughly.
and you're building a stoop.
No, not building a stoop, just building a porch roof, a portico, columns with a roof,
Just the roof. of-
Covering a porch.
covered
Covering
porch.
the porch. Okay. And so the setbacks are measured from the cantilever, even though it's not at ground level. And that's, I guess, for staff, right?
Sorry, could you repeat that question? I was looking at
So-
the elevations.
So the setbacks in the rear are being measured from the cantilever on the second floor.
The setbacks are being measured as they are noted in the advertisement language is maybe the quickest way to address that. Do you have a particular question about one of the particular elevation drawings?
So I'm talking about the rear bump out. That's what you're measuring the setbacks from on the second floor, the bump out. Not, because it's not at the ground level, right?
Right.
Yes, I believe so, yeah.
So it's the second floor that you're measuring from. Okay.
Building wall on the second floor.
Building
eaves as
wall on
well.
the second floor.
Sorry. Are we just putting a roof over the patio or are we doing something on the back too?
A roof over the patio?
Over the stoop?
Yes, the front entrance stoop. Yeah, we're putting a roof over that with columns.
Okay,
The typical portico covered porch, yeah.
okay. And then are you doing anything in the back?
Well, the back is where the cantilever is.
It's already there though.
No,
Oh, okay.
that's what we're trying to build.
Okay, that's what I was unclear of.
That's all we're trying to figure out here. What you're,
I thought I saw one already on the existing plan, so I was confused. Okay,
so all the setback is on the rear, right side setback to the bump out. Which is the bump out?
The bump out would be the cantilever.
Again, the cantilever. Okay.
Well,
The right
Yeah.
side setback to the bump out. Right side setback to the bump out. 22.5.
It may look more clear if you look at the side elevation, you can see the second story bump out from the side. Correct.
Yeah, I get that now. So it's a bump out on the second floor and a roof over the porch. front
Correct.
Porch, and that's it. Yeah,
that's when I finally got it.
this one.
Yeah.
Yeah, that's the one.
So the plans that are in here, we'll come back if you have any other questions. The plans that are here are from March of 2022,
March of 2020?
2022.
Correct,
The
yes.
applications from October. So the neighborhood outreach, did the neighbors get these new plans or did they see old plans? Maybe maybe the applicants would know better.
No, I don't, the plans never changed. My attempt to identify the setbacks changed.
They're stamped of March 2021.
Right, there is a building permit application still in force. So the plans are still there.
Do you have a building permit?
No, I applied for one.
Okay.
Yeah, obviously didn't make it through zoning.
So the notation 3/17/2022 is only pertaining to those red marks?
Right,
Yeah.
yeah, Blake and Megan and I were trying to work together to clarify the setbacks.
So the plans didn't change, just
Correct.
The drawing was
the
dated.
drawing.
Yeah, I'll be happy to chime in. Just in terms of, when we're writing the advertisement language and once it's published, it becomes final. We, closely scrutinize plans to the best of our abilities. And we worked with Joseph to identify the eave setbacks, especially as something that was different and required separate setback relief compared to the walls.
Okay. Well, I feel better that if the neighbors saw the original plans, which are dated in May of 2021. So then they would have been able to see them in October of 2021.
Now, there is some feedback missing.
We're missing 2.
Do you know anything about the feedback from neighbors that are missing?
The feedback that I got from the neighbors? Or-
Well, somebody did. There's,
Yeah, I don't have that information.
okay,
Do you go? Did you have any feedback from the neighbors?
there's neighbors that adjoin your property that did not sign off on it,
They didn't what?
did not sign off on the plans, did not show support for the plans.
They're the 2 that are pretty well impacted.
Well, I mean, we made an attempt to contact everyone.
But it says unable to contact 3 of them on Sycamore Street.
So we'd like to know more about that. If you can't speak to that, can the owners speak to that?
What, the lack of feedback from the neighbors?
The adjoining neighbors.
Yeah, again, Tony and Vivian didn't make attempts to contact them. I did it all.
Oh, you did the
And
feedback.
I made several attempts and I left my business card in there. They might have thought it was a solicitation. So yeah, I went through the neighborhood at least 6 times and that's how I gathered the signatures of support. And the adjoining properties, I don't know what to do if they never answer the door. So that's kind of where I left it.
Sending a letter?
Pardon?
Send a letter?
Well, I did. I put it in their mailbox with my business card.
All right. Anyone have any other questions? Anyone want to make a motion?
Motion?
Thank you.
I move the
That-
Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11780-22-UP1, subject to the conditions listed.
Second.
Motion has been made by Ms. Freshman, seconded by Mr. Kaplan. Is there any further discussion? Oh, I don't know. I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to approve the application has passed 5-0. Enjoy your renovation. All right, that concludes this matter. Ms. Bowen or Ms. Ryan or Mr. Bowen, would you please call the next case? It's past my bedtime.
Yes, Ms. Arthurs, and I would like to apologize in advance because despite my best efforts, I'm sure I will mispronounce 1 or 2 of the names in this application. The next case is case number V-11781-22-VA-2. This is a variance request by Shamuel Chowdhury on behalf of Nasir Uzman, Mohammed, and Gulshar Zubeya. the owners to permit a new addition that exceeds 50% of the aggregate floor area of the existing building on a lot that does not meet the area and lot width requirements for a semi-detached dwelling in the R27 zoning district, regarding a new side addition to an existing semi-detached dwelling in the R27 zoning district on the premises known as 5412 8th Street South within the Arlington Mills Civic Association. Staff recommends that the board adopt the attached proposed resolution approving the variance with conditions.
Is there any, there's no supplemental material?
We do not have any speaker slips or supplemental materials for this case.
That is major change in the evening. Is the applicant here? Yes. We just wanted to make sure that the applicant was here.
Okay. So we've had these cases before. This, the staff approval is based on, I think you think there's an error in the zoning, that there's not a similar allowance for existing non-conforming two-family dwellings in this district while there are in other districts. Why has no one made any effort to change that?
I don't know if I would necessarily characterize it as an error. It is certainly, changes to Article 16 have been proposed. Those are undertaken not by zoning division staff. Those are undertaken by our colleagues in the planning division, comprehensive planning, and we don't oversee their agenda.
But this is the case today, that the zoning provisions of 16.2.4B does not permit allowances for existing non-conforming two-family dwellings to be improved over 50% of the floor area. Then, if I look at the tax map, and I think we've gone through this before, this property is not unique. This property is like all the properties next to it in this whole area and throughout Arlington. So a legislative change could be made to permit this. So those are the things that we have to evaluate in the case to determine if there's a hardship. And the variance, the standards for a variance say if a legislative change can be undertaken, then we should not approve it. That is the standard. And it's a standard that we've adhered to in the cases that we've had up to now. So I'm just looking for feedback from you if I'm in error in terms of what I've said, that this county board could make a change to allow this to happen in not only in this case, but in the entire block, in the entire neighborhood and throughout Arlington, so that it could happen by right, and that they would have the same rights as other zoning districts. Okay.
I would say I have some disagreement with the way the phrasing of that. The zoning ordinance, stipulates, or the language stipulates that, it is reasonably practicable to formulate a regulation. There are certainly other conditions on this property that I think are also unique. This house was built very shortly before the zoning ordinance was passed in 1950, and then immediately became non-conforming due to the passage of the zoning ordinance in July, and I believe it was built in May. Had it been built larger at the time that it was first built, and I believe this is an argument that comes up in the staff report, it could have, the 50% expansion would not have been necessarily a problem had the floor area been larger in the first place.
But that condition, being built before the zoning ordinance was adopted, also applies to all of these properties and other properties in Arlington.
Other properties built before 1950. It does not apply necessarily to single-family dwellings or to two-family dwellings that don't have the particular characteristics of this property.
So the legislative change would be to grant this zoning district the same relief that others do. I don't know that that's impractical. I mean, that would, and it would apply, I think we went through this before, there's hundreds of properties like this in Arlington that are undersized in the zoning district. So anyway, that's my kind of counter to your argument that this is approvable.
Certainly understand the BZA can have different opinions. Thank you.
Question for staff.
Yeah.
Mr. Bowen, if this property were to be knocked down and rebuilt with this floor plan, would that be allowed? Does that change anything?
That is something that I will have to think about for a second. So please give me a minute to consider that as a possibility.
I don't know if that's relevant, but I'm trying to go through this in my head.
No, that's a good question because I
Yeah.
assume it's legal. Is it legal non-conforming or is it conforming?
Right.
That's a good question.
Right. By maintaining the current structure, are we saving something? Not we, but.
Would the applicant like to come up and speak? Thank you. I was looking at the CAF score.
Good evening. My name is Shamal Chowdhury. I'm just the agent for the owners, Gulshan and Nasir. The owners came to me late last year asking for this addition, and I quickly knew that we would run into this 50% rule. I've submitted for something similar to this in the past. You know, the main structure, the original structure being 800 square feet, but this has an additional 100. You know, 450 square feet total addition divided by two floors is not a lot of room to work with. Their main goal was to get an additional bedroom on the second floor. And even that, if it was in a smaller footprint, you would have to sacrifice the existing small bedroom in the back to get to that. So you don't actually gain a room. So, you know, I understood that we had to get through that hurdle. And then I took the footprint of the addition that is has been granted previously in this neighborhood and similar to a lot of other structures, which allowed for the 2 bedrooms and additional space on the first floor. And this structure in particular is set back a little further than a lot of the others in the neighborhood, which will tie into the next part, which is the setback in the back at 21 feet versus the 25 feet. But the staff put together some great metrics for all the numbers on this lot coverage and building footprint, as well as comparing neighborhoods. So I don't want to repeat that in the evening. So I'm open myself for any questions the board may have.
Anyone have any questions?
Mr. Kaplan, I believe I have an answer to your question. I believe you asked if this could be undertaken by right. There is, of course, an associated use permit for this project that requires setback relief. So that is not totally by right. In terms of the need for variance, the zoning ordinance does not generally regulate GFA of a building. This particular stipulation only applies to buildings of this variety that were built pre-1950.
So if the associated use permit were granted, then that provision would not apply and we would only be here for a use permit.
Were it to be entirely new construction. I
Entirely new
believe the
construction.
need for the variance is really predicated on the square footage of the property when it was built in 1950, directly before or 2 months before the zoning ordinance was passed.
Okay, my head hurts.
And yes, a further point there is that we would really only look at the maximum permitted lot coverage as well as the setbacks. In a semi-detached house in the RT7
Right.
district,
That
built
makes
to
sense.
56%, and they are well below that in their proposed
Right, so
conditions.
that makes sense.
Anyone have any other questions? Anyone want to make a motion?
I don't know where my colleagues are on this, but since I've sat through the others that we have denied, I do feel like I need to be consistent. I really wish that staff applicants would press the county board to take care of this so that we're not faced with, you know, making a hard decision here that we really don't want to make, but you know, if we follow the rules that we've been given, that's the conclusion that I come to now. So I really would press for legislative change. I think we've maybe even written to the county board and asked for that legislative change.
If I may add one thing, my relatives live in this neighborhood. I've done applications like this for 19 years, and this is this one rule that we always have to get over.
It should be
And,
changed.
right, and, and if, waiting for that to happen, God knows when that will happen.
Well,
So,
the thing is, you've been waiting 20 years if
Yeah.
nobody starts. So.
I've asked in previous submissions, and yeah, it's not the right person to ask, but yeah.
So I will, if you want me to make a motion, I'm happy to make the motion. It'll be my motion.
Ms. Freshman?
I understand Ms. Malice's concern, and this has come up any number of times. However, in this case, as I read through the staff report, I do feel that I'm persuaded that there is a hardship, and maybe the hardship is the inaction of the county board to rectify the problem. And we could, pursue that. And we probably, I believe we have in years past made a recommendation that somebody look at this and try to fix this problem. As long as there's that sort of legislative inaction, then I'm persuaded, and I would make a motion to approve if you're ready for that.
Just if that's not a motion yet, right?
No, it was an editorial.
Okay. I just don't want to be doing this, we're being, we can't, second guess the intent of this. Was there a reason that this was excluded? And we've debated this before, that there could be very well a reason that this was excluded. From a policy perspective, we wanted to continue to maintain smaller sized units so that they could be more affordable. To the extent that we expand units, make them larger, they become less affordable. I'm not saying that's the rationale, but I don't know if it's the rationale. So just like with other zoning issues that we have to deal with, we don't try to nullify the ordinance by saying that it was an oversight. So that's.
I think that the applications that come before us for these disproportionately fall in one section of the county, where
They're in North Arlington.
there's a majority of them are in South Arlington, at least the ones in the last 2 years since I've been here. I feel like that is somewhat of a hardship that as a South Arlington resident, I am obviously a little partial to. I do know that in the past, I did not agree with the motion where we denied the permits. So I would be in support of this approval going forward.
Before we get that, I want to take one step back without getting some groans. I think we're missing some feedback for 5407 and 54, whatever's next to it. It's blocked off on my list, unless I am missing it or I overlooked it. And those are the rear neighbors.
5407 would be.
And those are two neighbors that are going to be affected by the back. And so I'm not sure where I come down, and I hope I'm not going to be a swing vote here. But I'm not.
5407 is on the.
It is.
57 on that, 54
The
on that.
rear.
5409 is on there.
5407 is definitely on
Yeah.
there.
How about 09?
All right, so that's what we're missing is 09.
So, has
5407 is more impacted, right?
a half and, nah, I mean, half and half.
No, okay.
It's almost, in fact, I would say 5409 might even be more because it's right on the property line.
Do you guys have any contact with 5409? Did anybody?
On the back, no.
No.
Yeah. Could try to reach out to them again, but yeah,
Or did you try, or was an attempt made?
Did you talk to the back neighbor?
Both of them?
Oh, but, oh, we didn't. It wasn't when we submitted initially. I told him. Okay.
All right. Well, would somebody like to make a motion of some sort?
I will.
Can the chair make motions?
I'll make it.
Do you-
I move the Board of Zoning Appeals adopt the attached proposed resolution approving variance V-11781-22-VA-2, subject to the conditions listed.
A second.
All right, a motion was made by Ms. Freshman, seconded by Ms. Clark. Is there any further discussion? I will call the roll. Ms. Freshman,
Aye.
Ms. Malice,
No.
Ms. Clark,
Aye.
Mr. Kaplan.
I'm going to go vote no, but I think it's an easy no because I don't think it's going to be determinative.
No. Chair votes aye. Motion to grant the application passes 3-2. Congratulations.
Great, thank you.
Well, that's part one. And I would suggest that on somebody's work plan, we address this issue with documentation from our experiences once again.
Yeah.
County Board.
Yeah.
It seems very contradictory to me that we can knock this house down and build that footprint, again, assuming use cases, but it needs a variance. And that seems very contradictory to me. But I'm having trouble getting over the last part of that test, which is it can be done by the county board. Right, I can get through hardship, but I'm not sure I can get past the
But
county board.
we've been trying to do it for the county
I
board.
know,
and I
know.
do think
I get
that Ms. Freshman's
totally get it.
argument there is persuasive. We have been voicing our opinion about this for quite some
I
time.
think that meets hardship, but I don't think it meets, but that's fine,
Yeah, right.
Yeah.
Different threshold, different opinions.
totally.
All right, let's
I'm glad I
call,
wasn't the deciding vote.
let's call the next case.
Cedric, stay.
I mean, if you want to speak to the next one, you can. It's totally up to you,
It's just repeating the same thing essentially. So,
pretty much.
yeah.
I will read the case language just to formally enter it into the record.
Yes, thank you.
And I apologize because I will once again probably mispronounce the same names. The associated use permit for this project is is case number V-11781-22-UP-2, a use permit request by Shamuel Chowdhury on behalf of Nazir Usman Mohammed and Gulshan Zubaydah, the owners, to permit a rear setback of 20.9 feet to the rear addition, 20.6 feet to the eave instead of 25 feet to the rear property line, 21 feet to the eave is required, regarding a new rear addition to an existing semi-detached dwelling in the R27 zoning district on the premises known as 5412 8th Street South within the Arlington Mill Civic Association. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions.
Does anybody have any questions or thoughts? Anyone like to make a motion?
Sure.
This is hers.
It seems to be my purpose on earth.
You
I
have
move
many more.
Board of Zoning
purposes.
Appeals approve the attached proposed resolution approving use permit V-11781-22-UP2, subject to the conditions listed.
A second.
Motion has been made by Ms. Freshman, seconded by Ms. Clark. I will call the roll if there is no further discussion. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. Motion to grant the application passes 5-0.
Thank you so much.
Congratulations.
That concludes this matter. Will you please call the next case?
Yes, case V-11782-22-UP-1, a use permit request by Andre Camions, the owner, to permit a left side setback of 9.7 feet to the wall instead of 10 feet as required, a right side setback of 3 feet to the wall, 2 feet to the eave instead of 10 feet to the wall, 6 feet to the eave as required, a total aggregate of 12.7 feet instead of 18 feet as required, a rear setback of 19.2 feet to the stoop instead of 21 feet as required, and a front setback of 23.9 feet to the garage wall instead of 25 feet as required, regarding a carport enclosure with addition above, front porch, and rear stoop in the R6 zoning district on the premises known as 704 North Emerson Street in Bluemont. Staff recommends that the board adopt the attached proposed resolution approving the use permit, subject to the conditions listed.
All right, are there any questions for staff? All right, is the applicant here? Hi, come on up.
Everyone. Hi. I'm Andrea Camowens, 704 North Emerson Street.
Great, would you like to speak on your application?
Sure.
Okay.
So I'm not an architect or a builder. I'm a humanitarian aid worker. I bought into my dream neighborhood 13 years ago. It's a wonderful street with great people whom are all my friends. And I've been saving up for 10 years to make my home my dream home. And so I'm embarking upon a remodel. And I'd like to be able to put a brick exterior to the home. It's currently vinyl. So that's what's taking one side of the house 6 to 8 inches more. It's not that the structure is moving, but the brick side, the brick itself would, take it out a little bit. I'd like to build an enclosed garage. As an aid worker, I run a global program in 50 countries, often working in conflict zones. So I go on a minute's notice to some disaster, and I'd like to be able to have an enclosed garage. I currently have a carport so that I can keep my car safe when I'm gone for months at a time. What happens in Arlington in terms of break-ins and such. So in order to have a carport where I can open both car doors, unfortunately, the house was not built, the carport was not built wide enough. So I'd have to scoot into one side and, if I just built within the current carport structure, I would only be able to get one door open and have to stumble out. So unfortunately, that means I would have to have move a few more feet closer to the fence line. And then on top of the carport, I'd like to push out my bedroom so that I can have a bathroom that's larger than a closet, which is the size of my current bathroom. So the main issue is, how close I'm getting to the fence line. And my neighbors are all my friends. We do things together all the time. I cat sit, hamster sit, dog sit, house sit, pick up all their mails, and do a lot of things with them. And so they've kindly given me their letters of support, the houses behind me, to the side, and in front of me. So thank you for your consideration.
Could you state your name again?
Andrea
Last name?
Camowens,
And what is the address?
704 North Emerson Street. It's been a long night.
Does anybody have any questions?
If there's no questions, I am ready to put a motion.
Malice, are you good?
I am,
No rush.
what number case is this, 81?
82.
822 UP1, I think. Last name. Camowens, last name.
So hold up, I'm good.
Madam Chair, I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11782-22-UP-1, subject to the conditions listed.
Second. A motion has been made by Mr. Kaplan, seconded by Ms. Freshman. Is there any further discussion? I will call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Mr. Clark.
Aye.
Ms. Mr. Kaplan.
It's getting late.
It's an hour and 15 minutes
Yeah.
past my normal bedtime. I'm so sorry. Mr. Kaplan.
Aye.
The chair votes aye. The motion to grant your application passes 5-0.
Thank you so much. I'm
Enjoy
so
your
excited.
renovation
I
and
just
your
want to
dream
say
home.
thank you to your wonderful staff who helped me through the process.
They're
Megan,
amazing.
Megan and I had a call and I was like, I don't know what I'm doing.
Congrats.
Thank you.
All right, let's call the next case.
Next case is V-11783-22-UP-2, a use permit request by Elaine and Terry Ebby. The owners to permit a left side setback of 4 feet to the proposed side addition, 3.5 feet to the eave instead of 14.6 feet to the left side property line, 10.6 feet to the eave as required, regarding a new side addition to an existing one-family dwelling in the R6 zoning district on the premises known as 3817 13th Street South, Douglas Park. Staff recommends that the board defer the application to the November 9th, 2022 BZA hearing.
Why are we recommending that we defer?
To add the aggregate side that was missed when we advertised.
Got it. Is the applicant okay with that? Or
Staff error?
Yes, in this instance, we did miss an aggregate yard setback feature and realized that too late after the advertisement had been published. The applicant, I heard Ms. Freshman ask, the applicant was very understanding and very kind about this error. So we'd
All right.
appreciated that, that effort on her part.
fabulous. All right.
Motion?
Yes, please.
Beat me to it.
In case V-11783-22-UP2, I move deferral to November 9, 2022 BZA hearing.
Second.
Motion has been made by Ms. Freshman, seconded by Mr. Kaplan. I will call the roll because I don't think we're going to have anything to say. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to move the application to November 9th BZA hearing passes 5-0. Let's go to the next case, please.
Next case is V-11784-22-UP-1, a use permit request by Arthur Webb, the owner to permit a rear setback of 1 foot to the eave instead of 10 feet to the eave as required, regarding a rear detached garage on a corner lot in the R6 zoning district on the premises known as 123 North Garfield Street in Line Park. Staff recommends that the board adopt the attached proposed resolution approving the use permit subject to the conditions listed. And please note we received supplemental material,
Can you describe the supplemental material?
a neighborhood outreach letter.
Great. Anyone have any questions?
A question for staff.
Mhm.
Mr. Bowen, when was 3.2.6.82B enacted, which is the corner lot requirement for 1 foot for 10 feet?
I would be
accessory dwelling?
happy to do a little bit of research on that. I believe that has been in our zoning ordinance quite a while, perhaps as far back as
Not recent.
1950.
Okay, that's great. Thank you.
Anyone else?
Mr. Bowen? What is the policy reason for the 10-foot setback from the street?
That is not something I'm aware of offhand, but I can probably also do a little bit of research on that in the background.
I mean, is there a logical reason for that is the question, since
In terms of what we do as zoning staff, we're not super familiar with policy. We don't determine policy. Again, that's something that I believe I lost my mic for a second. Policy is done through our colleagues on the comprehensive planning team, and they outline that in their staff report when a zoning ordinance amendment is enacted. We are simply, typically administering, enforcing, and interpreting the zoning ordinance. But if you would like, I can certainly try to do some research quickly in the background to try to find the staff report there.
only if you have time?
I will certainly try in the interim.
I cited the wrong reg in what I just asked. And so just for the record, I really meant to refer to Article 3, Section 326A to C23, just to clear that up.
You just went very lawyer.
Yeah.
323, yeah.
I just cited the wrong section for the record.
Yeah, because it just seems like it's because we define it as the rear. Therefore, we give it a different setback. Okay,
Any other questions, or should we speak to the applicant? Mr. Webb?
Speaking.
All right. Floor is yours.
Yes, appreciate you taking the time to speak with me about this. So this is the only place on my lot that I can place a garage that works. If I turn the garage the other way, it will take up all the yard. So I went around the adjacent neighborhood and went 1 or 2 blocks, and this is what most people in fact have on a corner lot, and they're detached garages certainly within a foot of the rear property line. In addition, I went and got supporting letters from each of the, I want to say 1, 2, 3, 4 neighbors who it affects, and they have no objection to it. My main reason for wanting a garage is just to protect my vehicles, the vehicle break-ins, and also, to be quite honest, it's warm when you go to a garage car versus a unkept garage. The other issue is the trees. I have 2 very large trees in back, and they are constantly shedding and creating problems for me. I had to rent a car once recently, probably about 2 months ago, and it sustained about $15,000 from a tree limb falling. So those are my real reasons for wanting the garage. I think it's consistent with in the neighborhood. And I have support of the 4 neighbors that I would affect.
Thank you. Does anybody have any questions?
Madam Chair,
Yes.
question for the applicant. What would preclude you from possibly moving the garage a foot or 2 off that corner?
Sure. So if you'll look at the plat, at a foot, it's still a tight radius turn, but it's doable. But anything less than that makes it a challenge to turn off of my driveway into the garage.
I don't follow that, I guess. How does the radius change if everything just moves over?
So the issue is the distance between the garage and my driveway. So if I move it even 1 foot closer or half a foot closer, it makes a difference. It's because it's a 90-degree turn for me to go from my driveway to the garage. So I need as much space as possible to do that.
I guess maybe I'm not clear. Moving it towards First Road, does that cause a hardship in terms of radius?
Moving it towards First, you see Garfield. So I'm not asking for any relief there. But the issue is it starts to, if you look at the garage, I have a decent sized backyard. And even at the setback, I'm not asking for any relief there. It essentially takes up half of the backyard. I do want to preserve as much of the backyard as possible. But moving it up from the wall any more than a foot just makes the garage non-functional.
I think moving it a foot closer to the house would make it non-functional, but I think what Ms. Malice is asking is if you moved it a foot towards First Road into your backyard, if that would still make it non-functional.
So my understanding is the current setback requires me to be a foot off of that wall from the eave. And again, the lot is probably about the backyard is about 40 feet long. So the garage is 20 feet wide with 2 feet coming from with the setback. It leaves it cuts more than half of the yard off. So I want to preserve that as much as possible.
Any other questions?
Madam Chair, I had a question about outreach to neighbor 2928 South, First Road North. Was there any outreach done to that neighbor?
So all the neighbors that it affected, I did outreach to them and got their support. I'm gonna see 1, 2, 3, 4, 5. There should be five outreach letters there.
I think I see 4.
I only counted 4.
Oh, wait, is the supplemental material? that
There's one letter in the supplemental material for support.
That's 2121,
Yeah, that's
2921.
Yeah, that one's already counted.
Yeah, we already have that one.
I don't see 2928 or 2922.
Correct. So in our process, any neighbor that can see the change is considered an affected neighbor.
Okay, so I spoke to the 5 neighbors that were affected, and they all gave me letters of support. One of them was sent in directly, and I received a copy from that. So I got 3 letters of support for folk on Garfield Street, and I think 2 of them were on the side street, the first road.
Yeah, we're missing, I think we might be missing a letter of support then.
What do you guys think we're missing?
29, 28.
Right across
on
the
the-
street?
Right.
Okay.
That, because he mentioned 3 on Garfield. I only see 2 on Garfield.
How about the neighbor directly across the street on the other side of First Street from you? Did you reach out to them?
Yeah, I reached out to her and got her support, and she sent a letter in directly.
Do you know what her name is?
Her name is Mary. First name is Mary.
We're not,
Jennifer, Linda.
we have Jennifer, George,
She,
Linda, and Shauna.
So you're probably, so Mary sent her a letter directly.
Mary and Linda.
Megan or Blake, is there any chance that we missed it?
I will be happy to check that we do not have that located perhaps in the Acela online portal, Permanent Arlington.
Okay. I'm sure you guys checked that probably today, so it would be odd if you missed it, but
While he's checking.
Yeah.
Just a comment. I'm really torn on this one, and maybe more torn than I should be. But the county board has made a determination for whatever reason that corner lot should have a 1-foot rear setback, and this applicant is asking for a 1-foot rear setback. Us approving this is rendering that distinction meaningless. On the other hand, county staff has plenty of comparables on corner lots with some accessory buildings or structures at a 1-foot setback. So I am kind of not sure what to do. So I wanted to feel out what my colleagues are thinking.
Madam Chair,
yes.
I understand that there's some concern that 29, 28 and 29, 22 haven't commented. However, while they can see it, I don't think it has nearly the impact on them that 29, 21 and 127 Garfield do. And and they apparently have no objection.
I agree.
So the standard for a use permit is compatibility. And I'm just looking at the distances from, we're not approving it for all corner lots in all areas.
Neighborhood, right.
Right, it's not a blanket.
And there does seem to be a large number of rear detached garages within, two of them within a foot, 1, 2, 3, 4 within 2 feet, and 1 within 3 feet.
The difference is that most of them in the staff's chart were built before the
early.
zoning ordinance, and so they were built.
Sure.
And there's only one that had a BZA variance, and that was 3 feet.
That's why I'm really torn.
So but I think the compatibility issue still.
Doesn't take into effect the year it was built.
Right.
Thank you. Yeah.
Yeah, I would say that
I think I
you
might
can
agree.
make the case that this is compatible regardless of, it fits the neighborhood where it might not fit other neighborhoods.
Much appreciated.
Any other thoughts, comments? Anyone want to make a motion?
I'm prepared to make a motion.
That's fabulous. Go for it.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11784-22-UP-1, subject to the conditions listed.
Second. Thank you. A motion has been made by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? I'm going to call the roll. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to grant the application passes 5-0. Enjoy your garage.
Thank you very much.
You're welcome. That concludes this matter. Can you please call the next case?
Sure, I'll just mention that the next case was case number V-11785-22-UP-1, which was approved in a group motion at the top of the hearing. So I will move on to the following case. The following case is case number V-11786-22-VA-1, a variance request by Russell Riggins on behalf of Randolph, Pamela, and Venora Hawkins, the owner, to permit a rear setback of 19.6 feet to the building wall, 18.6 feet to the eave instead of 25 feet to the wall, 21 feet to the eave as required from the rear property line, regarding a new semi-detached dwelling in the RA 818 zoning district on the premises known as 909 South Scott Street in the Penrose Civic Association. Staff recommends that the board adopt the attached proposed resolution denying the variance. An alternative resolution with conditions has been provided should the BZA see fit to approve the application as advertised.
Anybody have any questions?
Madam Chair,
Yeah.
question for staff. The applicant could apply for a special exception use permit for this project, which is actually quite common in the zoning district.
Correct. I believe I noted that in the staff report that the zoning ordinance does allow the special exception process through the Arlington County Board as well.
And that goes before the county board.
Mhm.
Were they made aware that?
And it's in the staff report. I personally did not have too many communications with these applicants outside of those communications.
I'm sorry, could you repeat what you said?
Sorry, I was saying I did not directly communicate that to the applicants before the staff report. We did not have much communication
On this particular issue?
on this. Yes.
You did talk to them about other things?
Yes.
Okay.
We do our standard, series of emails to applicants.
All right. Yeah, that's my major clarification. Just wanted to confirm that, because this is not something that we typically see.
Any other questions? Comments? All right. Are the Hawkins here, or Mr. Russell, or Miss
Riggins?
Riggins?
Mr. Riggins?
I'm looking at something different then. Sorry. I'm happy to whoever wants to speak.
Riggins first, and then I'm Russell Riggins. I'm with Stanley Martin Custom Homes. I'm the builder. So you guys have read all the details. Basically, we're requesting the setback. So the current setback is showing, we're going to make the setback 2.5 feet larger than it is now. So I don't want to go into a bunch of the details. I assume you guys are bored with that already. And also wanted to thank you guys for staying up late with us here as well. Appreciate that. But I kind of want to tell the story of how this all started and why we are here, and maybe why we didn't pursue the method that you just stated. So this started back in 2019. We met with the BZA coordinator at that time, not Blake, and they suggested, hey, don't go for a variance. You don't need to. Just go ahead and move forward with your subdivision. And then at that time, once that's approved, you can basically do setback averaging and ask for a determination letter. So that's the method that we pursued. So through that whole CEP process and getting that approved, my poor owners have paid CEP submission fees, performance bonds, just standard submission fees. They've gotten the title report. They've had a photometric study done. They've had a fire flow test completed. They coordinated with Dominion. They sent out multiple sets of letters for the different stages. If and when this project actually moves forward, they'll be expanding the existing street, improving the community. They'll be installing new curb and gutter along in front of their property, as well as building a sidewalk in front of their property. So as the story goes, they finally got the CEP approved. They hired an attorney, got all the documents put together to actually file for the subdivision. And then at the same time, we put in our application for the setback determination letter. What then came back was they basically could not approve the setback determination without the subdivision being completed because the lot didn't exist. Then at that point, we said, okay, fine, well, we'll wait to get the subdivision completed. The subdivision can't be completed until until the house is demolished. So this goes back to the same issue that Mr. Clark had that he presented earlier, in that you can't make a lot smaller with the non-conforming building still existing. In this case, there's a mortgage on that house and a loan that needs to be processed. So without a determination letter from zoning, we can't move forward, or we have no, what the bank asked for is a viable path forward to be able to construct what we have planned. So we can't demolish the house, we can't remove the equity, which kind of paints us into a corner. So we had a couple of meetings with different staff from zoning. It was suggested by the administrator that we basically come to the BZA. So Blake is correct. We were not advised, so to speak, from him. We were actually advised from the zoning administrator to be here. So that's why we're here. I think just to address a couple things that are in that staff report. It did note about the hardship, and while I understand that based on the conditions that are there, it's rightful to say that maybe there's not a hardship because of the dimensions of the lot. However, I believe the hardship in this case, not necessarily that part or that aspect, but instead it is basically what we've gone to this point to try to get here, and basically the kind of circular loop that we were painted in terms of the subdivision setback letter and demolition that's being required. And then the last one was, is it general? And I would argue that this lot and these conditions basically are not something that's probably going to be repeatable anytime soon. So I would argue that it is a pretty unique situation. Again, because we're asking for the variance more of a way to circumvent what we could build by right if circumstances were different or if restrictions were different. At this point, I'll let the owner speak to a little bit of the history of the lot and kind of their experience.
Thank you.
Good evening.
You can raise that up if you would like. The whole podium will come up.
Oh,
More. Yeah, keep going.
That's it.
Oh,
I maxed it out. You're too big.
I would be at the bottom end of it, so.
can everyone hear me?
Yes.
Good evening, BZA board members and staff. Thank you for giving us this opportunity to speak about our case. I'd like to give you some historical background on my family and the property in question. My family's roots in Arlington go back to the 1860s when freed slaves began to settle in freedmen camps, searching for work and trying to make a way for their families. My great-great-grandparents married and were living in a home on 11th Street. William Edward Mosley, my great-great-grandfather, was a blacksmith by trade and would own and maintain his own shop on Columbia Pike for 47 years. He was always active and helpful in the community. My great-grandmother was born in 1905. In 1907, her parents donated a few parcels of land for construction of St. John's Baptist Church on Columbia Pike. They were always community first. And in 1908, began construction on the house in question, 909 South Scott Street. That house would become the anchor home. Scott Street was the anchor street. That was the neighborhood for the family. She was schooled in Arlington County. My great-grandmother was schooled in Arlington County until having to go to DC for high school, that being the only option for Blacks at the time. Her dream was becoming a teacher, and after graduating from Miners Teacher College, she was hired at the Langston School. Throughout her career, she taught at Langston, Hoffman Boston, and Kemper, which is now known as Drew Elementary School. Before leaving Drew in 1970, she also became assistant principal. Her career as an educator in this county spanned 37 years, and that was only half of her impact. She was very popular and influential in the lives of many families in the community. When I was young, people would stop us often and be overjoyed to see their former teacher and mentor while we were out. They often referred to her as stern and demanding, but always loving and a major factor in their formative years. One of her former students left this message in the log at her funeral. As one of Mrs. Ross' students in the class of her retiring year, I remember her as an exemplary educator and an Arlingtonian of the highest esteem. Those classroom lessons and her disciplinary actions are treasured. May God bless her memory. My great-grandmother was a member of the church next door to St. John's Church that I mentioned previously that her family donated land to help build. She was a member of the church informally her entire life of 98 years, formally for well over 80. She walked next door to church every Sunday until she no longer could. She was a member of the choir, board of veterans. She was also a significant financial contributor. She was on countless boards and committees, including being appointed by the Virginia Commission on Aging multiple times by governors from both sides of the aisle. She was interviewed by the Arlington County Library Oral History Project, January 16, 1987. It's a great read and has firsthand insight about her life in Arlington up and down the pike at that time. I have many fond memories of my great-grandmother, but something that I never understood until I became an adult was her need to always be pro-Arlington County. Every conversation with her was a history lesson. Every landmark we passed had a story. Every person who stopped us was a reflection on her impact. I realized all of that was pride. She loved Arlington. She told everybody whether they wanted to hear it or not. She loved Scott Street. She loved her home. She was proud of her land and hard work and dedication to the county that made it all possible. Allowing us to complete this project and restore our property as well as improve Scott Street for all the other residents would be another fitting chapter in our story. This is also about being able to stay in a community that was historically African American, and now we are one of and possibly the last of the on the block, last on the block. This can be a step forward in protecting a small piece of history. 6 generations of children playing on that street in that yard. Over a century of hard work and goodwill being good civic-minded citizens should count for something. I feel it's important to state we aren't big developers or people looking to destroy the community. Our circumstances led us to needing to make a decision on a house well over 100 years old. Lastly, my mother, Pamela, who grew up at the house and who asked for our help when the house became too dangerous to occupy, couldn't attend this hearing tonight. When we started the process in 2018, she was walking, talking, and selecting home accessories. Today, she is wheelchair bound. This is the last sentence. She's wheelchair bound, suffering from the effects of dementia. We feel this plan works best to give my mother a comfortable, handicap accessible home to live in for the rest of her retirement years. I'm asking that you please approve our variance request. Thank you for your time.
Thank you.
Does anybody have any questions?
I do have questions. Just, the question of why a special use permit was not pursued.
Quite honestly, it was never introduced as an option. This was the option that was given to us by the zoning administrator, or was told to us.
So, but you did read the staff report. Now you realize it was an option.
Right, but that was
Friday.
a week ago. Yeah.
Okay, thanks.
I know this is down the road, but the proposal is to put a duplex, basically, correct? Okay.
So, Madam Chair,
Yes.
I guess this is to staff. They're asking for setback relief, which is placement. Okay. Which obviously, in every other district, in single family districts, is a use permit and not a variance. The variance obviously has a different, much higher standard than a use permit. If this was a use permit, we would be talking about compatibility. And if we were talking about compatibility, we would have before us a chart showing other properties and their setbacks, and we don't have that. I would be willing to consider this if I had an idea of what the right setbacks were. You know, what if this was compatible? Again, it's a very unusual situation because it's, you know, it's really a placement issue, not a variance, and it's a quirk of the zoning ordinance that it's a variance. But absent any information on what comparable use, you know, setbacks there are, I can't judge it that way either. So I'm a little bit, you know, somewhat sympathetic, but on the other hand, I have no basis to say that this is compatible.
Can I speak to that a little bit? The surrounding properties to the left is a church. And then on the rear and the right side is both occupied by an apartment complex. Those, basically the church signed the letter that says they have no issue with what we're proposing.
Right.
Do we have those
contacted
letters?
the apartment complex.
I don't think they're going to reply, do they?
So they never
apartment.
did.
Yeah,
But
but
we
it's
actually
appropriate.
talked to them on the phone. We sent them multiple letters and emails, and we never got a response.
Not surprising.
And then to the question about the duplex is to help pay for this project for his.
To sell one side and keep the other. Got it.
So maybe Mr. Bowen, could you react to my attempt at working through this? You know, the fact that a placement issue would have a compatibility standard, but there's nothing that we can use to judge compatibility here. Is there any way that you see that we could judge compatibility?
The approval criteria for variance, you know, are not rooted in compatibility. So, you know, we did not produce a table in that regard. Had this been a different zoning district, you know, we would have provided that table. You know, should the BZA think that a compatibility table might influence their opinion and would be inclined to defer, it's certainly something we could produce. I would say from a staff perspective, I don't feel that it's appropriate given that the state code criteria for variance do not dictate compatibility as a consideration.
Right. That's yes. But, you know, I'm considering, you know, our power to grant a variance when we determine I can't make that case. You know, it's the quirk of the zoning ordinance that this is a variance. We would grant, I'm trying to think through on what basis I would even grant a variance under the compatibility thinking. Is there a hardship? Is there a, you know, kind of how would we rework this to get around that standard? It's not unusual. It's not certainly not economically damaged.
Well, I think it is somewhat economically damaged. I mean, that
The surrounding neighborhood.
the surrounding neighborhood, and then you did mention that there's a mortgage on there that.
Yeah, it's not relevant to us, I'm afraid.
Right, I'm still pointing to that as the hardship. It's the zoning ordinance and the rules within the zoning ordinance that are creating the hardship. So I think the statement is, if you apply, how does the application of the zoning ordinance create a hardship? And that's how it does.
We can't, I will never use the zoning ordinance as a hardship. I know staff sometimes does, but I can't use the zoning ordinance as a hardship. I have to.
I think it's the.
I mean, this lot seems to be smack in the middle of apartment complexes, church, right? That like there are I don't see on the picture on before us, the hardship seems to be that there's no single family homes, duplexes in that area. And that seems to be the hardship to me.
There's one on the Pike, but that's it. It's
I
at
mean,
the
why
corner
is
of the
that a
Pike.
hardship?
Why? Because there's no comparables. How do you value a property when there's nothing to value it with?
Then when
No,
all
but
the
we're
other-
not talking comparables right now. We're talking about variances. Why is this property, qualified for a variance?
Because, surrounding it are, mid-level high rises, and here we have a, single family home that's probably limited to what, 35 feet?
that would like to make it more
That would like to make it
comparable.
more economically viable and
My
They've
heart
got
is
more in that
there.
area. And
It's not.
I'm not sure that this is something, I mean, I clearly don't have a study on this, but I'm not sure that this is going to be, a repeatable incident that the county board can make a regulation for.
Well, they can. They could allow placement in the zoning district, use permits in the zoning permit, and they don't. Can only be done by variance, but they could change that. I mean, so I'm telling you, my heart is here in terms of, the zoning ordinance causes a problem, but I'm having trouble with the rationale of why we would and I'm searching for that rationale.
I'm trying to search.
So I think again, I think that the zoning administrator sent us here because they recognize that what we put forth in the original application does work and could be done by right, but it's more of a procedural and protocol steps or an order of steps that's causing the hardship or causing the inability to actually move the project forward, get the subdivision, get the determination letter. So this was just us presenting an alternative that may be approvable and get past the procedural restriction.
So I think from your point of view, the hardship is the mortgage. If you didn't have the mortgage, you would have been home free.
So mortgage and or loan to build a new structure. So no lender's going to give you anything if you
That's true.
can't prove you can build something.
Yeah, if you can't get a zoning determination letter, you're not going to get a loan.
Right.
Mr. Bowen, do we have any idea what the surrounding apartment buildings, churches are zoned? Right. I mean, I'm assuming they're not RA 8-18.
I believe in many cases they may be. I'll be
may
happy
be.
to pull up the zoning map. I believe there is some variety in the zoning along Columbia Pike.
They're likely to be.
I think most of the Pike probably is.
I'm clearly out of my depth
Yeah,
on RA
this is
18.
Penrose, right?
Yeah.
A lot of Penrose is multifamily. Matter of fact, I don't think there's any single family in Penrose
Oh, there's a lot of
there
single
are.
family in Penrose.
zoning.
I don't know.
Yeah, it came up in another context recently.
Madam Chair?
Yes.
So some of you may know that generally speaking, my position is not terribly sympathetic when a property is going to be raised and therefore you're starting with a blank slate. And we often have applications where a builder, not you guys, but a builder comes in and wants to build the biggest thing known to man and wants all kinds of exceptions from the get-go. And my position is, what the setbacks are, what the buildable area is, use that. And so as I look at this and I see, okay, so far, according to the advertisement, we're looking at a rear setback exception. And if that's the only exception, you do have a by right option, I assume. The by right option would be smaller, and maybe that is not your preference. But I'm wondering why that, given all of the complications and the mortgages and the, you have to do this in order to do that, but you can't do it because of whatever. I sort of fell off that train at some point. Can you just explain to me why, if this was in a different place and didn't have a lot of historical significance, and it was just an old house that somebody wanted to tear down and replace, why would you go through all of this hassle if you had a by right option?
Agreed, and that's a valid question. And I think that's the question that was raised and was being considered when they requested the denial of this application. I think the reason that we went this route is because if it was not for this procedural circular loop, we actually could build exactly what we're proposing, albeit in a different location, because we could move the house forward. All of the improvements, even giving the dedication of the property, we could build this by right. So what we're requesting is, since there's basically this little procedural loop, can we push the house back to give more leeway to the street to actually meet the front setbacks and get a variance for the back setback so that there is a verifiable path forward without having to deconstruct and compromise the house. But I do understand the point.
Well, and I guess, my colleague who is struggling with the whole variance issue, and I'm very sympathetic to that issue because the standard is very high for a variance as opposed to use permit in some other vehicles. So that's why, it strikes me as making your issue even more complicated by doing it this way.
I'll 100% agree.
If you had.
This
if
is
you
far
had-
more complicated.
yeah. When you have, it appears, the option to build a two-family dwelling on this site.
You're correct. We could resize the structure and fit within what's provided right now. The complication does become somewhat in the design. So you're going to lose a bedroom and potentially a bath if you do that. So we're devaluing the property, and maybe that's hard to take in terms of, if we could just get through this procedural hula hoop, we actually could build this design. So I think that is why the zoning administrator advised us to come here, was to try to see if we could find another way around, because that's what the conversations that we had with them were all about, is how do we get around this? How do we make this work?
Well, I think it's interesting, just anecdotally, this time of night, that the zoning administrator suggested that route as opposed to some other route. And the staff is denying it.
Yeah, I
Right.
agree. Yeah.
Having a real hard time with that
And
part of
yeah,
it.
she was here and she left.
She was here earlier, but yeah, she's not here now. So that really, to me, complicates it. Not only that there might be a by right alternative, albeit smaller, and, I get that part of it too. But that we're having a lengthy angst-ridden debate about what the options are when it appears that the conclusion the staff's come to
Is there's no option?
differs from the recommendation that the zoning administrator gave you.
Well, yeah, who knows? I just as I've, I really tried hard to come up with a rationale for approving this variance. I mean, I'm making a good faith effort here. But I can't do the logic of it. Particularly because as Ms. Freshman indicates, you have a by right option that is eminently approvable. You wouldn't need to be here if you went with that option. So I'm not, I'm getting negative now.
I feel like while I understand where everyone's coming from, I also know this neighborhood. There are some, it's a mix of so many different things. There's some weird structures on the pike right there that I've always marveled about. Two houses in particular. I do think I'm inclined to support it personally. And I don't know that I have you know,
So you
a
would,
fabulous argument for why,
you
but
would have to modify the resolution to show.
yeah, which I can't do. Or I'm not supposed to do.
Yeah, I think
There's an alternative resolution.
Great, let's look at that.
there is an alternative, okay.
Page 9.
Yeah, I think from my standpoint, staff has laid out a case for denial. I don't know why you got, the applicant was directed here, but I
I
wish.
think that's part of the reason that, I know that that's not in the code, but I think that's also part of the reason that I'm inclined to support it because they've been given the runaround so much. And if we go back, like, where do they go next? What do you guys do next?
So you need an approval to get the ball rolling.
Right, so we've taken, like I said, we started with the
No,
BZA.
just let me finish.
Okay,
So if you got a by right approval to get the ball rolling and you got your determination letters, does that lock you into this plan?
I'm not sure I fully understand the question.
Do you have to build, in other words, if you do it by right, you don't need BZA's permission, you don't need staff's permission. You can take that to the bank, show them that you've got a path forward, right? What you actually build later, you can come back and ask for something different.
Right, but we can't remove the bank's collateral under that premise. Like we've got to have, so the path forward has to be associated with what we're going to build, because that's what they're going to pull a mortgage
The
off.
path forward is to get the letter.
So-
Anyway, I'm just speculating. I'm gonna read the alternative resolution, but I think we need to move on.
Again, I think the point in our case is, this is asking basically the board for relief for being able to build the structure that was proposed, that is approvable, but that zoning can't basically give us the documentation that we need to complete the process.
Well, it's not approvable. You still,
The setback determination is approvable, and the subdivision is approvable. All of that's gone through. It's basically, we've gone through 4 years of working on this to get to that point, and all the money that they've invested in this, and
so
we still aren't.
Mr. Bowen, the setbacks are approvable without any further BZA action?
Some of the setbacks are by right. The rear setbacks, I believe, are not approvable. That is the source
So
of the
they'd have to
variance.
come to BZA to build this?
Let me clarify. The setback determination letter allows us to do an averaging. The averaging would be approved based on
The front.
the front. So with the house, the dwelling would actually be moved forward in that application, but we couldn't get that, so that's why we moved it back.
Probably not. Ms. Clark, do you have any thoughts? I think everyone's afraid to move forward because we don't really know where. No, I know. I
think we know where the vote is, -1.
I mean, I didn't really see anything in if we approve the alternative.
Not to put you on the spot, but I did just put you on the spot.
Yes.
Sorry. I need a proxy to make a motion for me. Unless somebody else wants to make a motion.
I mean, I'm going
Yes, definitely not the motion that I want.
But I'm going to make the motion, see if I get a second, and then we're going to vote on it. And if it fails, then we're going to make another motion.
Don't analyze it, just go.
I move that the Board of Zoning Appeals adopt the attached proposed resolution denying variance V-11786-22-VA-1.
Any seconds? Another motion, please. Yeah, Ms. Freshman.
Okay, my turn again.
It is.
Case variance V-11786-22-VA-1. I move the alternative resolution, which is approval as advertised.
I'll second it.
A motion has been made by Ms. Freshman, seconded by Ms. Clark. Is there any further discussion? All right, I'm going to call the roll. Ms. Freshman,
Aye.
Ms. Malice,
Aye.
Ms. Clark,
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to grant the application passes 5-0.
Thank you guys so much.
Hopefully you guys can move on.
Sometimes we get it right.
All right.
Need some more history on it. Some of that.
Very confused. Let's call the next case.
Case number V11787-22-UP1 was approved in the group motion. So moving to the next case. Case number V-11788-22-UP-2, a use permit request by Eric Hurt on behalf of Alexander and Amanda Zolan, the owners, to permit a setback of 21.6 feet to the bump out, 17.8 feet to the bump out eave and stoop cover instead of 25 feet, 21 feet to the eave as required, a setback of 17.2 feet to the stoop instead of 21 feet as required, a setback of 9 feet to the deck instead of 21 feet as required, and a setback of 13 feet to the wall, 12.1 feet to the eave instead of 25 feet, 21 feet to the eave as required, all to the rear lot line regarding a side addition in the R6 zoning district on the premises known as 3711 North Pershing Drive in Ashton Heights. Staff recommends that the board adopt the attached proposed resolution approving the use permit subject to the conditions listed.
Does anybody have any questions?
I do, Madam Chair.
Yes.
I'm looking at the advertisement, and it's asking to permit a setback to the bump out, but it doesn't say whether it's the left side or the right side.
I do notice that it does not specify a left or right side setback, and let me see.
It does say all to the rear lot line at the very end. So would that be the case that all these setbacks are requested from the rear property line?
Is one of those a bump out? Oh, in the proposal, is there a bump out? Oh, that wouldn't work.
Yeah, I believe we only did rear setback analysis, but I do want to scrutinize the plat a little bit before saying that definitively. So if you don't mind giving me just a moment.
Sure. Because the other thing is, this property has multiple stoops. And it's also set back to the stoop. And I think there's at least 2, maybe 3 stoops on this. Looks like 3.
I agree with Meg's assessment that the all from the rear property line do denote that these are all rear setbacks. This is a bit of an interesting proposal with a vertical expansion and some new features and some rebuilt features, but all of the new features requiring relief are from the rear lot line.
Yeah, I think that's inclusive, all to the rear lot line.
All right, so which are there two stoops in the rear?
Yes. One goes to the right, one goes straight back.
Yeah.
Correct, yeah, there are two stoops in the rear.
Had very similar triangular setbacks on my old house.
So is it to the new stoop? That's where the relief is being requested?
Yes, the new construction requires setback relief precisely because it is new construction.
The existing house is over the setback. Correct? A good portion of the house is
Yeah.
over the setback.
I believe it is technically over some of the setbacks. I can, yeah,
Okay.
not conforming in certain setbacks, sure.
All to the rear lot line. Okay.
All right. That's a weird shaped lot.
I have a quick question for staff. At the back of this application package, there are two blank forms with no signatures. Is that real? Is that accurate? We're not missing any signatures?
Correct. Sometimes when applications are submitted, the templates are submitted up front and then they're filled in later with signatures. And then in this case, I believe we had just the blank ones, which
I think we're missing a
frankly-
couple, so I just wanted to double check.
Yeah, I think these were part of their emails that they sent out to the neighbors.
Oh, all right. All right. Should we hear from the applicants or their agent? Or whoever has graciously stayed until 11 o'clock at night.
I'll just briefly, I'm Alexander Zolan, 3711 North Pershing Drive. Thank you to the board, particularly the staff. Thank you for staying so late. It's actually a riveting night. Actually really enjoyed.
Should be like reality TV,
I mean,
right?
there was some good stuff that went on.
You shouldn't say that. That's how I ended up sitting here.
I mean, it was interesting.
You'll be back next month then.
Yeah.
Everyone write down his name so that
I'll
we
be
can-
listening on Teams next month.
We might be calling you to join the board.
I might not turn it down.
Oh,
Yeah.
That's how I got here.
I'm writing it down. I'm writing it down.
I think I can't remember who said it, but I mean, we have a weirdly shaped lot. We were here about 5 years ago because we took out a deck that was behind the house and put in those stoops. And the board graciously gave us a use permit for that. Now I've got 3 kids and they're getting bigger. We all share one bathroom on the second floor. We want to stay in the neighborhood. We love the house. We love the schools. We love our neighbors. We like where we are. So we don't want to move out, but we need to make the house a little bit bigger. So we're trying to build on basically the exact footprint that the house is on right now. Most of the house, or a lot of the house, is over that setback. I think Eric has done a terrific job trying to figure out how to build a good looking house on top of where we currently are to make it a little bit bigger and a little bit more usable for our growing family. So I don't want to take up any more time, but obviously happy to answer questions, but I hope that you'll all graciously give us a use permit again.
I will say that I'm very sympathetic because I had a very strange situation too. My house wasn't built into the setback, but it was that far from it. And the board graciously gave me a use permit
Likewise.
that I never used, but I got to sit here because of it. So
Likewise.
All right. Does anyone have any?
Careful what you wish for.
I know. I really am writing
Write
your
his
name
name
down. Does anybody have any questions? All right, someone make a motion.
I would love to make a motion. I move that the Board of Zoning Appeals approve the attached proposed resolution granting the use permit V-11788-22-UP-2, subject to the conditions listed.
A second.
Motion has been made by Mr. Kaplan, seconded by Ms. Clark. I will call the roll because I'm not going to let anyone talk anymore. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The motion to grant your permit passes 5-0.
Yay.
Thank you very
Thank you
much.
for
Thank you
staying
for
so
staying.
long. We appreciate
That was
it.
probably
Great
pretty
night.
tough.
Mr. Chair,
Yes.
I move approval of the
Right.
minutes of Wednesday, September 14th, 2022, BZA.
Both of them?
No, she
No.
wasn't here. for the
No, I wasn't present on the other one.
We'll do the 14th first.
14th first.
Yep.
A second.
All right, motion was made by Ms. Freshman, seconded by Ms. Malice. I'll call the roll. I closed my Word document. Ms. Freshman.
Aye.
Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye.
Madam
Uh,
Chair, I
yes.
move that we approve the minutes of the Friday, September 9, 2022 BZA hearing meeting.
A second.
Thank you. Motion has been made by Ms. Malice, seconded by Ms. Clark. I will call the roll. Ms. Freshman.
Abstain.
Oh, right. Ms. Malice.
Aye.
Ms. Clark.
Aye.
Mr. Kaplan.
Aye.
Chair votes aye. The minutes have been approved.